years, I was appointed Judge President of the Industrial Court of Swaziland. I served in that position for a period of 8 years. Until the year 2006. But really in 2002, after Kenya experienced that transformation, it's when I started thinking about coming back, and I gave notice that I had the intention of not renewing that last contract. But I faced a lot of opposition from the kingdom, who wanted me to stay until the last day. The Minister for Justice then, Prince David, who's brother to the king, walked with me up to the airport the last day, still asking me to stay and serve the kingdom. I did not say that in the same year I lost my father. And so being the bigger boy in our family, I felt also the need to come back to my country. And that's how I came back with a letter from my Chief Justice, Anadale, to the Chief Justice of Kenya, greetings, and asking if his judge could translate into the judiciary. I never passed the secretary's door with that letter. That is how far we've come in this country. And I was lucky to join the Federation of Kenya Employers as the head of legal and industrial affairs, where I served the employers diligently with honor. And in that year, actually, I had the privilege of sitting with all the stakeholders, parliamentary committees in finalizing the 2007 labor laws. So I was completely involved in the crafting of all the labor laws we have today. In that 1 year, I served in that for the Federation of Kenya Employers. I cut my teeth in collective bargaining and advocating for employers, engaging with the unions, and hence, I must say, I have got very good skills in conflict management, in consensus building, which I believe is very crucial in the office we are seeking today.
Maybe Your Honor, you can fast forward now to your position as the judge.
Yes. To fast track that, I quickly joined after 1 year, I joined the East Africa community that is imported, Madam Chair, where I served for 5 years and honed my diplomatic skills, consensus building. And actually at the time I was appointed judge in the year 2012, I was in Brussels negotiating the economic partnerships with the European Union. That's when I received the news that I had been appointed judge. And I was actually not able to come for the swearing in because we were in these critical moments of negotiating the partnership with the European Union. So I came 3 months later after the judges of Employment and Labor Court had been sworn in July. I was able to come in October. They had been asked to elect their principal judge by Justice Mutunga, and they refused. They said they would not do so until I come back. They knew me because I had led them at the university. I didn't know them personally, but that is what they did. Actually, I remember Justice Kihara, commissioner here, had to be sent to them by the Chief Justice. And they told him also that they would wait for me to come back. And as soon as I came back, I was elected the principal judge of the Employment and Labor Court, which I guided very well from the Labor Ministry. It was a small court in the Labor Ministry. We had no offices, we had no furniture, we had no books, we had no seat in the judiciary. So I transitioned the Employment and Labor Court from the Ministry of Labor to the judiciary, and it was a formidable task. And we set up the systems and got the Employment and Labor Court to where it is today, including developing the rules, the charter, and getting the staff, because we didn't have any staff. All the staff in the Ministry of Labor, so it was a mammoth task, and with the assistance of the Chief Justice and CRJ then, we were able to achieve that, and even roll out the court to the stations in the various counties and establish up to 9 sub-registries. So those are the skills which have continued to hone today, which I believe make me suitable to serve the people of Kenya in the position of the Chief Justice.
Thank you, Your Honor. In an article appearing yesterday in the Study Nation by Gitau Warigi, and I quote, Your Honor, "The country needs a CJ with a vision, good temperament, and intellectual heft." So please explain to us, Your Honor, this statement by explaining your vision very briefly, also commenting on your temperament, and also commenting on the intellectual heft. Just briefly, Your Honor.
My vision for the judiciary of Kenya is to upscale and consolidate the gains so far in the access to justice and delivery of justice to the people of Kenya in an expeditious, fair, accountable manner, because that's the bottom line. All the other initiatives to do it are just enablers of that overriding objective to deliver justice to the people of Kenya in an expeditious, fair, equitable, inclusive manner, and in a friendly way, so that they feel wanted, because justice, the administration of justice, derives from the people, and our obligation in the judiciary is to serve the people. And so as a Chief Justice, I want to have a blueprint consolidating judiciary transformation. And its key elements derive from both JTF and CJT, because all we are doing is to upscale this, access to justice especially, and clearance of backlog, accelerate productivity of the judiciary staff, build confidence from court users, so that together we can have enhanced the rule of law in this country. It can enhance equity and equality in this country. So that, so what do I do as a leader? With my blueprint, I will engage everyone to develop it. I believe in delegation and direct leadership. I believe in participatory initiatives, and then delegating to the teams. I believe in the teams I work with, and I have looked at I would work within the framework of the 2019-2023 strategic plan. I'm more concerned about the 2017-2022 ICT master plan, because I believe what will unlock the potential of this country is streamlining and escalating the automation of the codes, the e-filing system, the case tracking systems, the case management systems, basically the monitoring and evaluation systems. That is what will take this judiciary to the next level, and that is what will get the judiciary to productivity levels which will be make a big difference to the people of Kenya.
Okay, Your Honor, what about your temperament, just briefly, because those details will come later.
I am very easy to work with. I am very amiable. I found myself everywhere I've been easy, very easy and comfortable with people. I've not had difficulties in my court proceedings many a times. In all those years, I have been a judge. And I believe I have built a lot of friendships across the judiciary and in the country at large, largely due to that emotional capacity I have to be in charge and in control of my emotions.
Okay, thank you very much, Your Honor. I will now request the Honorable DCJ to continue the questions.
My Lord, please tell us what you understand by the term organizational leadership. Give us 4 strategic goals you would use to achieve organizational leadership and how you would implement the same.
I believe there are different styles of leadership and leading an organization, but the one I espouse most is leadership by objectives. Establishing a strategy, selling your strategy to the people, developing it into short-term, medium-term, and long-term work plans, developing smart objectives and deliverables, selling those, and then delegating generally to your teams to develop the work plans, providing also for how those plans and objectives would be funded, and what capacity of personnel you need to implement your strategy in the short term, in the medium term, in the long term. That is the way I believe in dealing with leadership.
My Lord would not work alone and would not expect to succeed working alone, what teams would my Lord put together to assist in the optimum discharge of the judicial function and of the administrative function as Chief Justice?
First and foremost, I believe we need capacity in the office of the Chief Justice, first of all, because I've looked at the organogram, which is in the strategic plan, and I've been wondering why there is nobody who works with the Chief Justice. I was told that the Chief Justice comes with his people and they are all on short-term contracts and they come and go with the Chief Justice. My proposal, and having worked in the East Africa community with the Secretary General, is first of all to have a few key officials in the office of the Chief Justice to enable him to enable myself with my strategy. First of all, as the leader of the third arm of government, it is very, very important where we are to be able to unlock the matters which hinder us today. And I'm proposing, first of all, that I would, if it's possible, to have a principal liaison officer on a permanent basis in the office of the Chief Justice. He will be serving under the Chief of Staff to unlock the diplomatic initiatives in that office, the consensus initiatives. I would also want to work with a principal resource mobilization officer to assist me in unlocking the financial crisis which we find ourselves, which hampers our programs. So, and with that, I would also want to have a principal legal officer, a tripartite working in that office on a permanent basis, really, in addition to the other hand hoc officers. That was my experience with the East Africa community, and that's why they are funded 50% by the partner states. And we have to fund that organization through development partners, through that office, sitting in the office of the Secretary General to mobilize funds. And I think that, to me, that model would work very well for me. The key team in the judiciary also, it's the judges themselves, the magistrates themselves. You cannot achieve anything in the judiciary without them. They are my colleagues, my peers. I'll be only first among equals. One of my first.
Yes, my Lord, in fact, thank you for flowing into that area, because that's my second area of concern. So what have you identified from there? What is first the purpose of those employee satisfaction surveys? And what are you bringing in here, my Lord, as CJ, to right the situation from where it is?
First of all, I must appreciate that the satisfaction levels of staff and the court users are very high, contrary to the general perception out there. Actually, I was surprised looking at the percentages in every area. It looks like in almost 99% of the areas, really, that is where there is dissatisfaction. And that is the core of every initiative that the Chief Justice should embark on to unlock the potential of the judiciary, unleash it, so that we can increase the capacity of the judiciary to deal with the backlog. 2 years, 3 years, 4 years is bad for some dispensation of justice. And so the initiatives which are in the strategic plan include and the key enabler, in my own view, is the master plan, the ICT master plan.
My Lord, there are two issues here. There is the employee satisfaction, then there is the customer.
I was coming back now to the staff.
Okay.
With regard to the staff, and especially the magistracy, and judges also identified two key areas of dissatisfaction: the promotion procedure and career progression procedure. The levels of dissatisfaction with how, with that, in my view, especially the promotion, appeared to be very low, and I believe I would want to engage that area and have a document developed in a transparent manner to be implemented to completely deal with the promotion and career progression of staff, judicial staff in the judiciary. The other area identified is the disciplinary dispute resolution procedure, which actually is not even an indicator in that survey. Such an important issue, it was left out completely. Yet, this is a cause of staff suing their employer, judicial officers suing their employer, judges suing their employer, because they are not, and we don't have a framework of dispute resolution. We don't have a framework of sorting out dissatisfaction within the judiciary. We don't have the procedure of disciplining especially the magistrates and other judicial is not transparent, is not known. And if it is there, I must say it is not known. And that is the cause of so much dissatisfaction. I would want to address that as a matter of urgency.
My Lord, the magistracy include the Gotv.
Yes, they do include the Gotv.
There was some discussion pre-2010 constitution about the Gotv court. Please tell us what that was, and today tell us the structural scheme we have in the judiciary about the Gotv court, the challenges they face, and whether truly they are part of the judiciary.
I must admit that I'm not very versed in that area, but I will say this, that I know for sure that the process of recruitment of a Gotv is not well streamlined in the judiciary. And there's dissatisfaction in that area, in the manner the chief Gotv is appointed. There was also discussion of how far the special needs of the Muslim community, and especially those dealt with within the judicial system, will be catered for without violating their rights as a Muslim community in Kenya and in the world at large. I believe those are the concerns which Kenyans continue to engage in, so that Gotvis, who are equal partners, equal citizens, equal Kenyans, I mean the Muslim community, are treated equally, fairly, in the way, in every aspect.
My Lord, as Chief Justice, that would be your concern to settle, as would the Court Users Committee functions and their performance, because my Lord would, of course, be the chair, the National Council on the Administration of Justice. Please tell us what the impact of CUCs has been to date and how their performance is to honestly be assessed.
I noted that also as an area of dissatisfaction in the survey, that especially awareness. There's a big issue of awareness by the people of Kenya as to the existence of CUC.
What are CUCs?
I thought we are talking about the code users committees.
That's right. I'm saying you explain to us what those CUCs are, and under your leadership as both Chief Justice and Chair, how you would make them perform. Of course, you would answer that question with telling us what they are doing right now and how we would be able to assess their performance in improving access to justice.
Thank you very much. As the principal judge of Employment and Labor Court, I started the Court Users Committee for that court. I was also able to start the Court Users Committee for the Labor Court, in Kisumu, not to activate it because it was dormant when I went there. And so I have a very good understanding of how the judiciary should interact with its key stakeholders to resolve especially the areas of dissatisfaction. And that is usually the CUC's regular meetings with all the spectrum of stakeholders to where they give feedback to the judiciary, and judiciary answers their concerns, and we work out sometimes training programs, and together we agree on ways of resolving the problematic areas, especially the interfaces between the judiciary and the court users, which are problematic, especially the access to the registry, the facilities they use, accessible to them in the judiciary, taking care of the needs of the people with disabilities, dealing with issues of rudeness, issues of bribery, if they arise, and corruption. And so the satisfaction by the Kenyans will improve by the day as we enhance the capacity of the CUCs to deal with emerging issues. And when we do, because I believe we have been doing it, but also we don't talk very much about what we are doing. And that is why I saw in the survey that a lot of stakeholders were unaware that they in fact do exist. We had, for example, the marches during the Mutunga time. We had we have open days as models of engagement mooted out by CUC. In fact, Madam Commissioner, when I was at the ELRC, I started the first Inns of Court in Nairobi, which is still working today between the bar and the bench. And I had several engagements through the Inns of Court, which I started as a principal judge and which has been taken up by the current leadership, and it continues.
All right. My Lord, please tell us, as Chief Justice, my Lord would wear very many hats, at the minimum 5. Which of those does my Lord consider to be the most important, if that's possible? And how does my Lord hope to better the judiciary by the importance of that role?
The Chief Justice is the embodiment of the leadership and the institution of the judiciary. He is the face of the judiciary to the Kenyans who gave that authority unto us. So the Chief Justice as the leader of the judiciary, and the way he handles his internal affairs and external interactions with key stakeholders is the most important function of the Chief Justice, because those interactions will determine the internal satisfaction with his teams and the external satisfaction with out there, and to a large extent determine whether we are able to mobilize funds to achieve our objectives. We are able to get, for example, the issue of 41 judges unlocked. That role of the Chief Justice, the ability to build consensus as a leader and the embodiment of this institution is key and paramount. And you need a person who can be able to do that in a most judicious manner and amiable, diplomatic manner, yet decisive and honorable.
My Lord has sat in the Employment and Labor Relations Court since 2012?
Yes, my Lord.
As my Lord developed a particular type of judicial philosophy from my Lord's tenure at the court? If the answer is yes, how does that impact on my Lord as Chief Justice, particularly on employer-employee relations?
Madam Commissioner, I would not say that I have developed a particular philosophy other than what has been and a philosophy in me in every place I have worked. To administer justice in a fair, equitable manner, to treat people with courtesy, humility, and to make judgments which reflect the values, principles, and purpose espoused in our Constitution. Indeed, Madam Commissioner, the endings of our Constitution guide us in the way we interpret our law, in the way we implement our laws. Those are commands which we must have in mind all the time. And so, I just espouse the constitutional dictates, the principles developed over the years by the nations and the ILO, which have been adopted in this country as guides of what we call decent work and gender and human rights infused employment. Those are dear to me, and their values which are neutral and not biased in any way.
All right, thank you, my Lord. Now, is there a disconnect between the law and society? In case your answer is yes, how does my Lord as Chief Justice and leading an able team of judges and magistrates intend to reconnect law and society?
In fact, this builds on from where we were with the interfaces between the judiciary and the court users, because the court users are the embodiment of the society out there. So that is going on and is going to be escalated, and the communication channels, especially how we communicate the good things we do, because there's so many good things we do as a judiciary since JTF and SJT, I believe. And under the guidance of these commissioners too, there are very good things which you do. How well we communicate this will be part of my communication strategy to the people of Kenya. There is the issue of education and training within and without. And there must be also interaction in those trainings. We should also have joint trainings with the people out there, stakeholders. I believe that there's room for that, for training as we engage. I believe there's room for social awareness training of our judges. Social awareness training focuses on the values and the principles and the culture of the people, which of necessity a judge must be aware of as they dispense justice. And it's in that understanding that our decisions will become better and serve the people of Kenya more and more. I believe in that dearly, and I would embrace it fully as a Chief Justice.
Thank you, my Lord. As one of the major roles of the Chief Justice, one of the 5 I mentioned earlier, is being President of the Supreme Court and being the jurisprudential head of the entire institution. My Lord is aware that there's a difference between criticism and critique. So would my Lord first critique the performance of the Supreme Court to date? It's 10 years old. And 2, how would my Lord, as President of the court, bring a difference in that court?
I am aware that the Chief Justice, you are also the President of the Supreme Court, and therefore the first among equals in that court. I'm also aware that I have very senior judges in that court, many of whom I have personal interactions with, because as I said, I am very easy with interactions, be they upwards or downwards. So I also have studied and I do use many of the judgments of the Supreme Court in my decisions. And I know, for example, I can identify some decisions which I think have not stood well in my own. The first one, which has given us a lot of problems at the E&LRC and in the magistracy, is the Law Society decision on Weber. That decision, my problem is with the effectiveness of the orders often discharged, issued by the Supreme Court. Not only in that case, in Mitubel case, and in Moro Ateto case, very good jurisprudence, but in my own view, that more needed to be done, especially in crafting effective orders, because justice orders are not issued just for the sake of it. Justice is dispensed to sort out problems in society. And therefore, the other day, just before Justice Maraga left, we had concerted efforts for him to explain to us in the ELRC and within the magistrates the meaning of that decision, Supreme Court decision, because it has created a lot of confusion across the board. in the handling of WIBA matters.
WIBA.
Yes, it's a problem. So those are the issues, and up to now, and that will be, I would want to give that attention as soon as I am Chief Justice.
It is that I am looking for the benefit of all of us.
Yes.
So what are you going, my Lord, to do as the jurisprudential head of the judiciary and of the of the Supreme Court in particular? What are you going to do so that WIBA does not happen again, if according to you WIBA is not good jurisprudence, and Muruatetu does not happen again, if according to you Muruatetu is not good jurisprudence? What is the role of my Lord as President?
First of all, I'll clarify about Muruatetu. My concern is not the decision itself, but how far the Court of Appeal went in having resolved very well, dealt with the issue of mandatory the death. I mean, say mandatory, that declaring death sentence and as not a mandatory sentence. It's how far I thought they should have gone so that to deal with minimum sentences which are as harmful to the people of Kenya, especially in matters sexual offenses, and also there's also the issue which I don't know how it was addressed as to the
so
place.
How would my Lord address it as President of the Court?
We are collegial as judges of the Supreme Court. We sit in caucuses. We meet in colloquiums and we purpose to engage in manners, in areas where we could improve the jurisprudence. And that's my approach, being a very democratic leader, very collegial leader, would be to want to utilize the jurisdiction of the Supreme Court to revisit its own decisions. I know some of those matters will come again because we have decisions being made at the lower level, which will come back again, and so there will be opportunity to revisit some of those issues, coming again through the High Court to the Court of Appeal. So there's that opportunity. And when we get those opportunities, it will be my time to use my collegial engagements, in my view, very good qualities, which I have to create consensus within the law, and I also like good dissent, because it is in those decisions where we develop our jurisprudence. So my ability, Madam Commissioner, in building consensus, which I will do with all those judges there, and they are all my friends without exception. In that, I have had workings with them, including you, Madam Chairman, in the JLAC. I've worked with you in morning meetings for a long time. I've worked with each one of those judges. I know them personally.
True.
And I am able to easily deal with them at that level.
Thank you, my Lord. Finally, from this end, that court, once every 5 years, is likely to hear the presidential election petition. Do you know what the court may have done in the last 1 year to improve its preparedness in discussing that major petition that comes once every 5 years? Part 1 of the question. Part 2, what would my Lord say has been the success or lack of it in the manner the court has handled the last 3 presidential election petitions? I
know, as a matter of fact, that we have Supreme Court rules 2020, I believe, which have been developed to better the procedures of the court. And since that is the main mandate of the court, I believe that will aid in handling of. We have the Supreme Court elections rules also, which I believe have been tackled in that process to improve the manner in which the court handles.
Any specific one, my lord?
Yes.
Any specific one?
Specific?
Any specific rule you are talking about, my lord?
I believe I have come across the Supreme Court Rules 2020, if I'm not wrong, in my readings, and which I suppose is an improvement on the previous rules of the court. And although I have not had an extensive interaction with the specific rules which have been developed, and you would understand why, being how busy we are at the level we serve. So we tend to engage with the Supreme Court matters when they directly affect the issues we are dealing with. But for the purposes of preparing for this interview, I believe I've interacted with new initiatives in that court in development of regulations and rules, which I believe will help in improving the capacity to handle future election petitions. Then coming to the issue of the petitions, I have interacted with 2013. Is it 2013? Rider 1. I've interacted with Rider 2, the 2017 ones, and my issue is that there is uncertainty from the polling stations to the tallying centers to the national sector, how that impacts the election and the final decision result. I think these areas of disparity in how the Supreme Court went about those issues in the Mutunga case and in the I call it the Maraga case, Rider 1, Rider 2, and the values, the principles in the Constitution, how they were applied to the election process, the importance of the polling station as a primary area of universal suffrage where the people speak, vis-a-vis irregularities which might occur along the way, how we, I believe those are the areas which of disparity in those decisions, and jurisprudence will develop as we move on in those areas, no doubt, Madam Commissioner.
Thank you, my lord. Thank you, Chair.
Thank you, Honorable Acting CJ. I now request Commissioner Honorable Judge Wasame to continue with the technical questions.
Thank you very much, Prof. Chair. My lord, my questions will be based on the issues you raised with the Honorable DCJ Acting Chief Justice, and I think also with the Professor. You said you left the country because
yes,
you felt your life was threatened, isn't it?
Partly.
Partly.
Yes.
Simply because you were called to the office of the DCI.
If you knew who Senior Superintendent Mashiri was. If you interacted with the...
There are more of them currently.
If
So the
you
people are
knew,
not
Commissioner, with what was happening at that time of our history, and having received real threats in the corridors of this justice, this corridors of this court, while discharging my duties as an advocate, as a very young lawyer, by the way, at the age of 28, you would understand where I'm coming from. But more importantly, I left because also an opportunity arose because the Kingdom of Swaziland advertised for positions in this country for us to apply.
So is Chief Justice Nduma Nderi a person who is, every time he's intimidated or threatened, is likely to leave the jurisdiction of the country?
Not at all, not at all, Chairman. I'm very courageous. I'm absolutely courageous. To take that role I took at that time of our history, very, very few would have dared do that. I can guarantee you. When I had my wedding, at that time, because at the same time when I married, most of my friends could not even dare attend the wedding. It's only the people I was working with at that time who had the courage to come at St. Paul's Chapel to witness that wedding. That's not a period anyone can take for granted. We know what happened to the people of Kenya at that time.
Okay, my Lord, when you are answering the Honorable DCJ Acting Chief Justice, you said there is uncertainty and disparity in the jurisprudence in terms of the election petitions or decisions rendered by the Supreme Court in Raila 1 and Raila 2. Can you tell us two disparities or uncertainties that is apparent in your view from those two judgments? And I'm just quoting what you said, my Lord.
First of all, Commissioner, the interpretation of Section 83 of the Elections Act and its impact on the election process, the use of the term and all, and whether it's conjunctive or disjunctive, and therefore whether one who wants elections to be nullified need to show that there was a violation of law and constitution, and that only suffices to nullify an election. Or they must go ahead and show that those contraventions in the law and the constitution did in fact impact the actual votes. That's an area of disparity in those two decisions. The other area of disparity is the weight, the fact that in the Maraga, in the Raila 2, we had changed our rules, election rules, and introduced peculiar electronic rules in the Elections Act. And therefore, the issue of transmission of votes was very prominent in Raila 2. It was not in Raila 1. And to a large extent, that impacted the way the judges decided those two matters. Those, in my view, are two key areas of disparity.
Okay, the Supreme Court is allowed to depart from its earlier decision. Would CJ Nduma Nderi depart from Maraga 1?
If I became CJ,
Yes. God willing.
God willing, that very heavy responsibility will be thrust upon me. And if I were to state my position right here, I think that will not augur very well for my sitting in those cases. So I do appreciate very much your concern, but I would want to reserve, not to answer that directly. But as judges, we must keep on exploring our own decisions, because the Constitution gave that mandate to us. And therefore, we can change today's decision tomorrow, depending on the circumstances and the facts and understanding of the law, the interpretation of the Morgan case and how it was applied, for example, in Raida 2. Really, they used the understanding of and, the ones used. Those are areas which judges will engage in and fit them.
Okay, which means, my lord, you are not willing to take a position on Maraga 1 and Mutunga.
I think it is not right for any judge to do that.
Okay, fine. In Mutunga 1, in Mutunga case 2013, the Supreme Court used the words burden of proof, standard of proof, and evidential proof interchangeably with respect. What do you understand by those terms? And what do you think is the standard of proof in election matters, especially presidential? And presidential election is unique, my lord. It's not an ordinary election matter.
That is, my lord, very correctly another area of disparity in those two decisions. The standard of proof, whether is it the intermediary one, whether it is on a balance of probability. There is disparity in the way that was handled in the two cases. The way it came out in the Mutunga case was not very, very clear to me. That intermediary test, which was developed in that case, it's not definitive and leaves room for divergent discourse and consideration. And I believe Maraga 2 did engage extensively on that, and they arrived at a differently crafted test. I do not know whether it is intermediary or it's on a balance of probabilities. But the test in Maraga 2, the determining factor was factual. The facts that they stand dictate that we decide that the dictates, the principles in the Constitution were not adhered to. And I think when you deal with us, with the standards of proof described in so many words, has to be on a case-by-case basis to unravel what the true test is. And so that uncertainty persists, in my view, of what standard is applicable in an election petition.
My lord, we want to get your position, and that's what the Honorable DCJ was asking. What, in your view, should be the standard of proof in presidential petition against ordinary election petitions involving MCS, members of parliament, governors, and senators? What should be the standard of proof in one side and the other side. And now that you are presiding as the Chief Justice Nduma Nderi, God willing, 2022.
The standard of proof in civil matters and electoral matters should not differ, in my view, whether at the parliamentary stage or the presidential stage. Strictly speaking, these are civil matters, and the principle, the burden of proof. But with regard, we are very well guided on how to deal with these issues in terms of Section 83 and the relevant provisions in the Constitution. We have the principles which tell us that constitutional edicts which say that this standard of accuracy, transparency must be achieved for an election to be free and fair. And therefore, when you infuse the constitutional edicts into while interpreting Section 83, I think the matter should be very clear. But as we always say that the law is very clear. But when we get into the discourse, it becomes not clear. But I believe, in my view, the dictates of the Constitution must prevail all the time, because we give it to ourselves. And we must adhere to those standards which are contained in that Constitution we gave ourselves. The values, the principles, and that is what impacts the manner in which we interpret that we arrive at the standard of proof in the presidential election. And I do not believe that those edicts apply only to presidential elections. They apply across the board. Only that the Supreme Court has expanded its jurisdiction to deal with parliamentary matters, which were supposed to end at the Court of Appeal level. And so there was not going to be an area of disjoint if the Supreme Court had stuck to its jurisdiction given to it expressly in the Constitution. I believe there was a bit of craft in the extension of jurisdiction of the Supreme Court to deal with parliamentary elections.
Why I'm asking, my Lord, and I'm consistent, is that in a presidential petition, the case is decided on affidavits filed by the respective parties. There is no cross-examination. There is no re-examination to trace the veracity and the truthfulness of the evidence proffered by the parties. While in ordinary election petitions, everything is tested through cross-examination. And as a judge doing trial, you will be able to know who is telling the truth. Therefore, is it necessary for us to separate the standard of proof in ordinary election petition from that of presidential petition? That's what the question I'm asking. And I want you to give some highlights.
From where I come from, I hold the view that the principle, the manner in which an election should be conducted at every level, as found first of all in the Constitution, and the principles, the procedure that must be followed, is a guide as to the standard which of proof that must be applied by the court. If the edicts of the Constitution are mandatory, and we are enjoined to implement and enforce all of them, I believe there should be no area of disparity in presidential and parliamentary elections. Only that the statutory provisions guiding the statutory provisions guiding the processes may differ. No, they don't differ, because yes, they do, and the difference in any statutory provision should not impact the edicts of the Constitution, because that is the base. And so, while saying that parliamentary elections ought not to have gone to the Supreme Court in the first place, I believe that the standard of proof should remain universal, as we gave to ourselves in the Constitution.
Okay. You said you have wide experience in labor matters, and you're one of the most experienced judges, as you said, having been presiding judge in this country almost 4 years. You also worked outside the country, so you have a lot of labor knowledge.
4 years, my lord.
As a presiding judge?
5 years.
5 years, okay.
Yes.
5 years. Thank you for the correction. Are you a judge who treats everybody equally and fair?
I have never known otherwise. I do that all the time. And every person is fallible, though. And the thing is, well, as a judge, you exercise your decisional independence, and litigation, unlike mediation or other out-of-court methods of settlement, all the time, and most of the time, is for one person and not the other. And so, people will always express dissatisfaction with the decisions which come from the court. Because when they come to court, they have high expectation that the decision will go their way. And therefore, and that is the exact reason why the decisional independence of a judge is paramount. Otherwise, the judiciary will be haunted forever. The judges will be restless. They will be haunted, as is happening, and it is happening right now. Haunted by their decisions. Instead of people going on appeal when they're not happy with their decision, they file a complaint. And that is why, and I forgot, when I was being asked questions I didn't forget, I'm very concerned about the vetting process of complaints before they get to the JSC. No, before, and by the JSC, before they graduate to a disciplinary, to a process, an inquest, where a judge is required to come and defend himself. That vetting mechanism, I would want to pay a lot of attention to it, because I believe it has become a big cause of concern to the constituency of judges and magistrates in this country. Because, again, there's no document which tells us the standard of required for a matter to graduate from a committee. Like happened during Mutunga's time, we had the committee chaired by Supreme Court Judge Wanjala. And at that time, being the principal of the Employment and Labor Code, that committee interacted with me continuously when complaints came from my court. So they made me aware of it, and in those interactions, almost all matters which would have otherwise graduated into judges being summoned before the JSC were resolved. And so my suggestion is that the heads of courts, the principal judges, the heads of state divisions, the judges, very senior and honorable, should be involved initially by that JSC committee in the vetting process, and to find out whether the genuineness of these complaints and whether, in fact, these are matters which are an attack on the decision or independence of a judge. And I must tell you that once a judge has been summoned to appear before the JSC to answer to charges, the amount of time you take a lot of time out of your work to dedicate yourself to that matter. We hire lawyers all the time to come and defend ourselves, and judges are paying the suffering in that respect. I would want a transparent vetting mechanism, as happened, although it was not documented during the tenure of Justice Wanjala. There is evidence that almost all those matters never arrived to be considered fully by JSC. That is my answer to this question. And that is why we are inundated every day with complaints which ought to be appealed to the next level. How are we supposed to work as judges? Because the time you take out of your schedules to give justice to the people is entirely now dedicated to a matter before JSC. And if you're going to have 10, 20 judges appearing before JSC at any one given time, the psychological trauma the judges go through, I, as a Chief Justice, would want to address that as a matter of urgency in developing a transparent vetting criteria, taking into account that we serve the people and we are also the people, and we should not be haunted because of the mandate they have given unto us. And that is my belief, Commissioner.
Okay. My Lord, I request you pay attention to this quote made by a judge: with the greatest respect and at the risk with the greatest respect and at the risk, unfortunately, of appearing uncharitable to the learned judge, his judgment was somewhat conflated, not least because it was difficult with great circumspection to discern the findings of the court and the reasoning thereof, as opposed to the submission of the counsel and the pleadings in the case. The learned trial judge was enjoined to be dispassionate and was required to be guided by the facts emerging from the evidence in the case and to apply correctly the law to such facts. He was bound to adhere inter alia to the national values and the principles under Article 10 of the Constitution. It was not in the purview of his jurisdiction to engage in speculation or conjecture, much less to show partiality in the dispute. A judge should never take sides or be guided by extraneous matters. A judge is required to be guided by the evidence before him, from which facts emerge to which he or she should properly apply the law. A judge should not be intimidated or be influenced in his decision by status, wealth, power, or influence of a party, and a weaker party does not have greater rights by dint of his or her station in life, though the court may be more sympathetic to such party. In a nutshell, litigants are equal in the eyes of the law, and none has greater rights than the other. The Constitution enjoins every judicial officer to be fair and serve justice to all without jurisdiction. Is that a reflection of you?
That is the Cholet matter, which
I didn't say it's the Cholet
matter. That is the Cholet matter which I decided.
Yes.
And I remember those very words from one judge who sat in that Court of Appeal panel, which dealt with that decision in the Cholet matter. And the way I understand the role of a Court of Appeal judge, and we have a lot of writings on that. Sorry.
Excuse me.
My understanding of the role of a Court of Appeal judge, pardon me, should never, a Court of Appeal judge should never ever be involved in that kind of frolic about a judge who handled a matter below him. To me, that was completely out of step. All the other judges in that panel considered that matter in a very considerate way. And I believe, in my view, that particular judge was guilty of the very things he was talking about there. And that is one matter which I still believe ought to have gone to the Supreme Court, so that all those issues are dealt with, so that we know who indeed was partial and who was impartial in that matter. That is my belief.
Okay. Again, one of the other judges also described you like this. I don't know whether you agree. It is clear from the phraseology employed by the learned judge that he took an extremely dim view of the manner in which the appellant dealt with the disciplinary process that led to the removal of the first respondent. The learned judge considered the entire process as fatally flawed and contrary to the law. He saw this as asymptomatic of an enthusiastic and insistent, overzealous, even attempt by the appellant and its chairman in the person of the Honorable Chief Justice to hear the matter and deal with the first respondent in a partial manner, even if it meant breaching the law in the process. With respect to the learned judge, he appears to have floundered in the same marshy bog of erroneous zeal with which he charged the appellant, and that is why the learned judge collapsed and conflated two separate and distinct disciplinary processes and mistakenly used the statutory markers of one of the tests to the other with the inescapable consequence of erroneous conclusion. Is that a reflection of you?
Commissioner, I must first of all say that...
and that's also another judge, it's not one of the judges.
Commissioner, I know you are involved in that matter as a commissioner. And I know it involved the judiciary as a family, and some people had taken diverse views on what happened within our judicial family, and so a lot of emotions were expressed, not just in judicial decisions that were made at my level and the Court of Appeal, which reflect largely what some of the wordings used. But I must say, and I repeat again, this, I believe, is a decision which should have gone to the Supreme Court, because I believe there was a lot of partisanism in the way the matter was handled. And a judgment, how do you judge your colleague? How do you pontificate against your colleague? We are guided against that all the time in the principles which we espouse as judges and a family of judges. So I disagree with all those sentiments.
You disagree with those sentiments?
Yes.
Okay. In paragraph 125 of your judgment, this is what you said also. It is difficult to understand the shortcut taken by the very eminent papers of the legal profession in a situation where the mandatory procedure that will have been followed speaks so loudly from the express provisions of Section 32 and Regulation 25 of the Judicial Service Act 2011. That's what you said.
Again, I say, Commissioner, you are involved in that decision,
no,
which I criticized. You are involved in it, Commissioner. And again, I say, this is a decision which should have gone to the Supreme Court. I do not agree.
You do not agree with your own statement?
I do not. I mean, that was a judicial decision which I believe will stand the test of time in academia. And that is where it belongs, because it was impugned.
Okay.
And I don't have to answer for it, but posterity will, and academia will. And if it ever sees the light of the day, if it had seen the light of the day at the Supreme Court, maybe we'll be talking a different story. So, Commissioner, in a matter where you are involved, I think you should not take so much time on it because you also have personal views about it.
Okay. I have no personal views, but let me ask you, leave alone the language used by yourself and the judges, and let's come to, and that's why I said we want to test your understanding of the law. And in this case, you equated disciplinary matters to that of a criminal trial. And you used, I think, the law of criminal trial in all its aspects, and that much you overturned. Is that the position?
Completely misunderstood by the Court of Appeal decision. But it's not true. That is not my understanding.
So you don't...
And I'm saying again, you are involved in that matter. You cannot have an objective judgment about what I said there. It's only an independent tribunal, in this case the Supreme Court, which can pass judgment.
So you completely don't agree with the decision of the Court of Appeal? And I will leave it there.
I don't agree with it. I'm bound by it. I don't agree with it. Well, I'm not supposed to agree with it.
I wish you well, my lord.
Thank you, Commissioner.
Just a small clarification, Your Honor. You talk really passionately about judges who appear before JSC, but just also to clarify, there's so many complaints that come to JSC, Your Honor, which we don't escalate to even to the judges, because we find they are merit-based or they are at the discretion of the judge. So I just wanted to put that information to just clarify. There are many that come and we don't escalate, but there are some that we find that the judges need to come and explain. So I don't know what you feel about that.
Thank you, thank you.
Because there are also complainants who really bring genuine complaints, Your Honor. I'm sure you agree that some of the complainants who have come to us have really genuine cases that we must address.
Madam Chair, my concern is what I would want to be done is to have a transparent criteria developed so that there's certainty in that area. And especially we know the place of decision-making independence of a judge in the way that those complaints are handled. And that can only come up in a criteria developed through a consultative process involving the judges themselves. Because believe you me, commissioners, it's taking a lot of effort from the judges' constituency, so much of it, and taking them away from their work when they should be serving the public. Those many matters, having spent so many hours, and most of those matters eventually are dismissed by JSC, the public is suffering. When you take for example, a whole 8 months dealing with a matter, hiring an advocate, and you don't get costs in that process.
Point is noted, Your Honor. I now turn to Honorable Commissioner Judge Majaja to ask his questions.
Thank you, Chair. Good morning, my Lord. Before I deal with your writings, I just want to follow up on what my fellow two commissioners have talked about, particularly two things. You talked about the Weber case and the Muruateto case. Maybe briefly, just tell us, what do you think is the role of remedies in the whole question of legal transformation, in your view, in terms of the remedies the Supreme Court gives or the High Court or your court gives in terms of achieving the goals of transformation? Maybe you just explain to us briefly.
First of all, remedies coming from court must be clear and effective for purposes of implementation. Two, those remedies must adhere to the edicts of the Constitution to advance those areas which the Constitution zeroed on for the people of Kenya to advance.
Okay. So in Wiba case, what was the remedy? Maybe you tell us and the public, what was the remedy given by the Supreme Court?
In the Wiba case, the court nullified or upheld the decision of the Court of Appeal, which had nullified the High Court decision, declaring parts of the WIBA unconstitutional. And therefore, we got back to the original position where work injury disputes, work injuries should be dealt with by the director. And they should only come to the courts on appeal.
So basically what the Supreme Court, if I understand, was that it was asserting the mode of alternative dispute resolution, isn't it? At the end of the day, it was saying, look, Parliament has created a mode of resolving disputes. This is the mode and we are upholding it. Am I correct on that?
The remedy came short.
No. That was the issue, really. I'm not talking about the remedy. First, let us understand the issue.
The Supreme Court upheld the view that there was nothing wrong with the compensation within the process in the WIBA, and therefore we should all resort to it.
Yes.
There's nothing
so
wrong.
Basically, they were saying there's an alternative process.
Yes.
And that process should be upheld, isn't it?
Absolutely.
So what was, and that you agree is part of the constitutional...
and I agree with that decision fully.
Okay, so what is the problem with the remedy? What was the remedy? The remedy itself?
The remedy was, the issue is that at that particular time, we had many matters pending in court. Hundreds of matters, if not thousands, pending before the magistrate courts and pending before E and LRC, filed at different times and were awaiting conclusion. So there's an issue of now, how do we deal with matters which were dealt with before the promulgation of WIBA in 2007? How do we deal with matters which were filed after the promulgation of WIBA, but before the act was nullified by the High Court?
Okay.
How do we deal with matters which were filed before the determination of the Court of Appeal?
So basically what you wanted is the court to give a structured approach.
A structured remedy which now would inform the magistracy, which is holding so many matters and dealing with them in different ways. So and that is why we actually, the court, the principal judge in our court, wrote to the Chief Justice and asking him, please give us clarity so that we know what the magistrates should do with these matters which are pending before them, so that we know what we should do with matters, because we are getting different courts dealing with the matters differently because there was no clarity in the judgment.
Okay. Now, don't you think that also it is the responsibility of your court dealing ex cathedra, dealing with matters, because the Supreme Court has said, basically it has said, this is the process. Don't you think now it is the role of your court to say, or to deal with the cases on a case-to-case basis, like you are interpreting the Constitution, say, okay, the Court of Appeal has said, the Supreme Court has said this, therefore, if a matter comes before us, those are now the issues the court should consider and give, so that it is now also your responsibility as a court dealing with these issues to give direction.
And that is exactly what ELNRC is doing. But of course, the different judges coming up with different approaches. The magistrates are at the same time also dealing with matters before them in a different way. So we've had caucuses with the Law Society because they have been, and the stakeholders are also very frustrated about the way they are being handled by different courts on that matter. And we are saying that having had initiatives, the Chief Justice with the stakeholders to resolve the issue, and up to now, there is no satisfaction, especially from the court users. Then we have to wait for our individual decisions, which we are making, to go all the way back to the Supreme Court. How long will it take?
Okay.
How long?
And that brings us to the other question. In such circumstances as the Chief Justice, first of all, you are the head of a CUC. There is a problem which now you agree the court may not be able to solve. And on the other hand, you are engaging with stakeholders, FKE, Gotv. What is, because I get the feeling sometimes in Kenya, we want to dump everything on the judiciary to resolve. And you as a Chief Justice, what is your role in telling the stakeholders, telling them, look, this is actually a matter for legislative intervention, for example. Go and make the law. The Supreme Court has said we have a problem. So how do you, as the Chief Justice, deal with that particular issue? Because if we say the case reaching the Supreme Court actually means that somebody has to appeal. And you know the people dealing with those kind of cases have no interest. Their cases are small, and they have no interest in waiting for 3-4 years. So what is your role as a Chief Justice?
If I'm appointed Chief Justice, I will deal with it, engage with the matter immediately, because I know it is hurting.
Okay.
And I will take a stakeholder approach to try and deal with it and resolve it.
Okay. And Murwatetu case, what was the problem with the relief in that case?
First of all, I know. I mean, when we were in school, I mean, learning law and reading landmark decisions of great judges, there's a role of obiter dicta in great landmark decisions, where it is clear to the court that a decision being made is likely to impact many other situations, such as minimum sentence.
In Murwatetu's case,
yeah,
the ratio was about the death penalty, relating to the two people, isn't it?
Yes.
The applicants. But as a court, one of the objectives of the court is to develop jurisprudence.
Yes.
And to give appropriate relief. Appropriate relief. In your view, how does that jurisdiction to grant appropriate relief gel with the duty of the court to develop jurisprudence? When you're confronted with such a matter, how do the two relate?
Commissioner, that is what I was saying in different words, to develop the law. The obligation of the Supreme Court, being the apex court, to seize those opportunities which come so rarely, to then develop the law to deal with the problematic areas.
And so you agree that is actually what Murwatetu did?
But why are we having a problem with the minimum sentences in all critical areas which were not even touched in dicta?
Well, let me put it this way. What did the Supreme Court say in Murwatetu? Why did it say that the minimum, mandatory minimum sentence, mandatory death sentence is unconstitutional? Why did it say so?
Because it takes away the discretion of a judge.
Based on what provisions of the Constitution?
Based on the first of all, the decisional independence of discretion of a judge to weigh the facts of a case and arrive at an appropriate decision, which discretion is also taken away in every situation where you are faced with a minimum sentence. To me, that was a cardinal issue here.
That was the cardinal issue.
Yes.
So in the sexual offences cases and the sentencing, what is the problem there?
The problem is that the discretion of the judge to deal with facts of each case on their merit.
So you
Has
agree,
been-
you
yes.
agree that in fact Murwatetu's case opened the door for resolution of minimum sentences.
Opened the door, but it was not definitive.
It was not definitive. In what ways? Because you're saying the court has said the court has to have discretion. So are there cases where the court should not have discretion in sentencing, and if so, what is the constitutional basis for that argument?
If indeed then that has been taken up, is if that decision opened that path to deal with all similar cases, not necessarily death sentence, then I would say then the criticism may be unfounded.
Thank you. So let us go to the next, your writings. You have brought for us very good cases on the judgments you have delivered. I'll just go through each of them and ask you a few questions. The first case is about, it was a three-judge bench about the payment of agency fees for persons who benefit from union services but are not members of the union. Am I correct?
Yes.
And in the West, it's a very contentious issue. They call it right to work.
Yes.
Right to work. And two judges upheld it and one judge dissented. Just a small issue I want to ask you. You used a lot of, you made reference, both the majority and the minority made reference to jurisprudence from other jurisdictions extensively. And in fact, it's a hallmark of your court to refer to jurisprudence from other jurisdictions, international treaties and standards. What would you say about the concept or the doctrine of what I would call constitutional borrowing as it relates to the work of the Supreme Court in terms of jurisprudential development, particularly having regard to what the Supreme Court has stated in the past?
In novel areas where we don't have a local jurisprudence, such as that case we dealt with there. In addition to considering the context of Kenya as a country on a particular set of facts, the court has an obligation to be guided by precedents from jurisdictions all over. And I think they have done that consistently in their in fact, the many decisions of the Supreme Court, which I enjoy reading, very good decisions, and they do extensively quote from many jurisdictions. I think is a good thing to do, when you are dealing with tackling novel areas.
What is the caution that the Supreme Court has expressed even when you do that? It has always said something. It has always given a caution.
First of all, a judge doing that must be aware of the circumstances and the legal framework in which those foreign decisions were decided. Sometimes we may borrow precedents without understanding the legal framework and the context in which those cases were determined. So we must be careful as we do that to make sure that we are dealing first maybe with similar circumstances, similar statutes, and all that, so that we do not misinterpret the foreign precedents.
The second case you dealt with was one of HIV and AIDS status, discrimination based on HIV and AIDS, and you've actually found that there was discrimination. This was a case of direct discrimination. Can you just tell us an instance where the discrimination would be indirect say HIV, a situation that would arise where discrimination would be indirect, or under what circumstances does indirect discrimination arise?
Indirect discrimination in many workplaces occur in disparity in terms and conditions of service in organizations where we have cadre from different racial backgrounds. So that you would in some situations find that a firm which originates from a particular place and therefore has been able to bring cadre staff from that where the company originated from will within its structures quietly remunerate equal staff quietly.
Isn't that that is actually direct discrimination? I'm talking about an issue where you have a neutral, the indirect is you have a neutral policy, but its effect is, so you don't know whether you have a neutral policy saying we shall give, we shall limit medical expenses to 10,000 shillings without being aware that you have people who are on retrovirals, isn't it? So you have an ostensibly neutral, so the effect is indirect. But back on your issue, and it's a case in which you dealt with, isn't it? The issue you have just spoken about.
Yeah.
You dealt with this was the case of Cambridge, we know it.
Yeah.
You dealt with the trial case, and in the High Court you upheld. What did the Court of Appeal tell you? What did they say about your judgment?
I've actually not engaged with it because with that judgment of the Court of Appeal.
Okay.
I've not engaged with it yet.
Okay.
I'm very happy nowadays with the case back we are receiving from the from
But you know the Court of Appeal dealt with it.
I did not receive case back from from it.
Do you know whether the Supreme Court dealt with your case?
The Cambridge?
Yes.
Oh, I would really love to
because
follow that.
There are very few cases that the Court of Appeal deals with, I mean Supreme Court deals with. So that case, that's actually one of the ones they dealt with, and I'll tell you why.
Yes.
My colleague, Commissioner Warsame, he talked about the way you have. In that particular case, the Court of Appeal said, look, you failed to consider the evidence that Cambridge presented. That's what they said.
Yes.
They said you just took the plaintiff's case and never considered the other case, despite the fact that they had filed extensive documents. But maybe I will not pursue that because you have not read what the Court of Appeal and Supreme Court, that's what they said. They said, both of cases said you had failed to consider the both sides equally, which is a serious criticism, but nevertheless one that the court made. That brings me now to that issue. What is the difference between discrimination and differentiation?
Differentiation cases do arise in affirmative action situations where you could be doing the same thing but you're treated differently for lawful reasons. Discrimination is unlawful.
Is unlawful. It's on those prohibited grounds.
Prohibited.
But this differentiation is discrimination that is justified.
It's justified and lawful.
And lawful.
Yes.
So in that case which you have were trying to mention, and not even that case, you have your company, let's say Kenya Railways, for example. They have engineers, grade X, job group M, earning 200,000 shillings a month. They want to invest in a system that changes the way in which the trains work. And none of the engineers qualify for that particular, they are all engineers. And they discover this gentleman engineer from Nigeria who doesn't have a degree, but he has invented a system which resolves that problem. And when they call him, they headhunt him actually, and they tell him, we need you here because we want to invest in this thing. And he tells them, I want you to pay me 800,000 shillings per month. And they bring him and they pay him here. The engineers complain that this is discrimination because we are on the same group, but you are paying him 800,000 because he's a foreigner. Is that discrimination?
Remuneration and terms of condition of service should always be based on a transparent policy. So and where that does not happen, it creates, first of all, a lot of discontent and suspicion. So, for starters, whatever differentiation you make, for it to be lawful, it should be open and transparent. Unfortunately, this is often not the case. And that is what brings the sort of cases we deal with, which sometimes may not be justified.
Okay.
Yes.
Again, I would urge you to read what the Court of Appeal said in the case which you decided. The other case is the Sonko case. And just probably explain, all of us know what employment is. And this is an issue that I don't know whether it has excised your mind. I know it came from a Court of the Appeal decision. Sonko is an elected member of parliament, governor. But in terms of jurisdiction, forget about the Court of Appeal decision. Is election as a governor an issue of employment?
Yeah, before I answer your question, let me say this. This almost 10 years since 2010, we are faced with that issue of forum shopping, constitutional division, employment and labor, different code users. Some file same case in both. Indeed, as you can see in that, the history of that case was initially filed at the High Court, was transferred back to ELRC.
So tell us.
While I was in Kisumu, and by the time I dealt with it, it had been dealt with by 3 different judges for a whole year, and many decisions made, and the judges recusing themselves in the matter, and it was brought to me 2 days before the Senate proceedings by the principal judge exercising his powers, telling me that I know you're able to deal with this matter and deliver a judgment before the Senate proceedings. You can see that ruling. I delivered it in a record day, 1 day, after hearing very extensive submissions. And the issue of jurisdiction had already been determined by a different judge. So it was no longer open to me to entertain it. I'm very conscious of that. And after my decision, the petitioners have moved quietly back to the High Court.
No, so the issue I just wanted you to clarify for me in terms of as a principle, we know what employment means.
Yes.
So is the election of a governor an issue of employment and labor relations, in your view?
In my view, elective positions, strictly speaking,
Yes.
are not employment positions.
Okay.
But there was a difference. For example, like in the election of speakers, where before I made that judgment, there were preliminary objections on the jurisdiction of the court to handle.
No, that one.
Just a minute, and
Yes.
that went to the Court of Appeal, and was decided by the Court of Appeal that we had jurisdiction.
Yes.
And that is how I dealt with it now.
No, you are bound by the decision of
the Court of
Appeal.
Appeal. So it's
Yes.
it's a
problem area.
It's a problem
It's
area.
a problem area.
It's a problem
Okay.
area.
Let me move on to the one or two final issues before I wind up in my time. You have talked about, God willing, you'll be the Chief Justice, and one of the issues you'll be confronted with is the same issue you are talking about, management of complaints. And probably when you're the Chief Justice, there'll be a new amendment to the Constitution saying that there's an ombudsperson, who will deal now with the complaints, not a parallel process for judges and magistrates dealing with with complaints. And for the public, the issue, unlike for us judges, they have said, in fact, the Judicial Service Commission is not doing enough to discipline judges. How, if that is the thing on your table, how would you deal with it? You will be faced with an ombudsperson appointed by the president. You will be sitting here as the JSC, and you will be addressing the judges and magistrates. Tell us briefly what you will be telling us that and our judges that we need to deal with.
First of all the judiciary and independent institutions must be free from direction and control from anybody, and that is a constitutional edict we gave to ourselves. 2, all independent institutions must self-regulate and come up with viable self-regulation mechanisms, like we've done throughout the judiciary ombudsman and other mechanisms up to the JSC level, which we deal with public complaints. I have looked at the satisfaction report, the court user satisfaction report. The satisfaction levels.
No, the question I ask is very clear.
Yes.
You have come in, constitutional amendment has passed, the first person on
has
the door.
passed already.
No, I'm giving you a scenario.
Yes.
Because it is something you have to factor.
Sorry, I didn't get that.
We have no control over that process.
God forbid.
Yes.
Commissioner, let the judge answer the questions, please.
Yes.
I had not gotten the fact that it has passed.
No, I was giving you a scenario saying you come into the office. This was my question. You come into the office, you find the constitutional amendment has already passed, and the person knocking on your door is the ombudsperson.
Yes.
So what is, in light of the problems you have identified in the disciplinary process, what will you be telling the JSC and the judges and magistrates? That's what I wanted to know. Because you have to project forward and have a vision to deal with that. Just that's what I wanted.
I'll start from the point that the judiciary authority is delegated to us by the people. What the people decide, for example, in passing a constitutional amendment like that, is a command to us as a judiciary. And if that will see the light of the day, my only obligation as a Chief Justice is to make sure that it is implemented in a most just and fair manner. And that will be my communication. And we will be able to work out the mechanism of dealing with the ombudsman, who I believe will be a member of the JSC, and therefore if he's out there, he's still with us, and we will find a fair way of dealing with both sides.
Okay. Finally, and my final question, you talked about your defense of the Mutugiba 4. You confirm, in fact, there were acts of torture of your clients, that in fact they were convicted based on that confession, and that finally the state conceded. Just tell us, how has that colored your perception of the work you intend to do as the Chief Justice? Thank you.
First of all, I do not take what Kenyans, the progress we've made by giving this constitution to ourselves in 2010, knowing and having experienced what many people went through in the 80s and 90s, having participated and actually experienced violation of dignity to the extreme of Kenyans, where confessions were extracted in very, very, very difficult environment with the complicit of the Office of the Director of Public Prosecutions. We've come a long way. And with that in mind, I would never ever wish that for anyone and for Kenya that would ever see that happen again to anyone. And that is a north which will give me impetus and focus to uphold justice for all.
Thank you very much, Commissioner Judge Majaja. And just to emphasize that, Honorable Judge, when we ask for the sample writing, we normally are interested to see your skills in writing judgment and not so much the merits and demerits, because that is discretion. I just wanted to let you know that we don't get into merits and demerits because that borders on discretion. We normally look at the skills in writing those judgments. I'm sure that's what Judge Majaja was looking at. Thank you.
Thank you.
Commissioner Ajero, can you go ahead and ask questions? Oh, yeah.
Now, Honorable Judge, I'll very briefly go again to the issues of jurisprudence. Then we come to, I'll try to match your skills with the job you are seeking. Now, the sample writings that you've been referred to, there's no doubt you write well. And I'd initially intended to ask you about those decisions, but my colleague has done a good job in that. Now, I'm interested in this case of Equare, because it seems to like it was groundbreaking. And there are two key areas, the one of discrimination based on the issue of HIV, and also the wage disparity. Now, just tell me so that I can understand, your reasoning and how you came about the decision. What exactly informed you, particularly on the issue of wage disparity? Because it's a common area amongst employers where you find that two people are being paid differently for the same job, and particularly women suffer more. The gender inequality when it comes into the women are paid, vis-a-vis men. I'm not sure what could have been the influencing factors to you as a judge in coming up with this groundbreaking decision.
First of all, Commissioner, thank you for that question. This area of discrimination, especially against women, is very well written and researched by ILO and these institutions, and they have promulgated conventions, declarations in that area, which guide courts, different nations to deal with matters discrimination. During my time, especially that time when I was writing that judgment, I had initiated interactions for training judges of E&LC, and got an ILO to directly train E&LC judges on awareness of discrimination, different sorts of discrimination. I myself, having been a judge president of Labor Code in Swaziland, I had vast experience in that area. It was my desire that all the judges of the court interact with it. Two, I'm very passionate about mothers and girls. It's a period of maternity leave. Employers fight tooth and nail to limit maternity leave to 1 month and even less. In fact, that we have embraced 3 years of maternity leave in Kenya is a great progress for women in this country.
That you mean 3 months, not 3 years, I'm sure.
3 months, 3 months. So that is, that background I had, Judge,
Okay.
as I dealt with that matter.
Now, tell me, as a follow-up to that, how, if you became the president of the Supreme Court, of course now as a Chief Justice, how you would be able to use the law in ensuring that you're able to anchor, this development of jurisprudence to protect women, especially when it comes to wage disparity. How you would be able to progress it so that it becomes all-embracing.
As a Chief Justice, all I will do is to implement our Constitution. We have such a great Constitution. Article 2.5, Article 2.6, Article 10, Article 20, Article 159, Article 259. They have commanded us to develop the law using especially international instruments. It's sitting with my colleagues who I believe would have very amiable relationship with. I'm sure, and I regard them with very high esteem. We should be able to do groundbreaking development of the law in areas which impact our children, our mothers, our boy child, especially now, completely under siege, and persons with disability, and deal with all forms of discrimination.
Yeah.
Yes.
Now, the reason why I'm asking this, my lord, is you see the nature of our patriarchal society, and you find that, the influences, the way we are brought up as men, sometimes will also influence how we project our decisions. Now, I'm just wondering, as the leader of the institution, if you could just explain very briefly how you would be able to also use your influence so that even as you're making decisions, these prejudiced influences that come from the way we were brought up in society don't project in the way we make the decisions that end up now continuing with these inequalities. How you would take that, because again you accept this decision of independence on the part of judges, but how would you now use your influence positively to
First of all, thank you very much. The Kenyan judiciary has completely embraced training and education. Thanks to Chief Justice Mutunga JTN. And the greatest instrument I use as a Chief Justice, in addition to the collegiality, the key to unlocking that is awareness training, social context training. It's a big instrument in transitional nations in transit from oppression to freedom. I had occasion to interact with the context awareness training a lot while I was in South Africa, where Canadians usually visited to train us in that area. And in particular, I remember very well Chief Justice Catherine Fraser of Alberta, Canada, who is a champion in context awareness training. And the doctrine that judges in their decision making choose values and not precedents. When you're dealing with high caliber judges like we have in the Supreme Court, you persuade them through training, exposing them to the correct, to peers from other jurisdictions, such as Chief Justice, I think Emeritus, Catherine Fraser, who was so forceful in their rendition in these areas of law and context awareness training.
Yeah. Now, the other section of our society that has been discriminated against so much is transgenders. I don't know whether in your career you've been confronted with a situation whereby you've had to deal with a situation, with a case relating to discrimination against the transgenders, either in writing or hearing the case and how you've dealt with it.
I've not dealt with an actual case, but they have, what's the name of this organization? One of the organization in Kenya, human rights organization, has invited me severally in their training programs for LBGT, and I've had occasion to interact with them a lot and to give them to make presentations to them. And our court, the Employment and Labor Court, I think the organization is KELA, is it?
Okay.
Also, we attended many trainings during my time as a principal judge to sensitize us in those areas. Of course, we know what our constitutional position in those areas, and difficult areas as they are because of our constitutional edicts. But these societies evolve, and our constitutional dispensation in that area will definitely one day reckon with it.
Yeah.
But I have seen groundbreaking High Court decisions by some of our eminent judges dealing with the matter. And so I'm aware of it.
Okay. Now, coming to you as an individual, I must say that even when I was also much younger as a lawyer, I heard a lot about you in handling those cases that many other lawyers, we must accept or are frightened of, of handling them, defending, the likes of George Anyona, and the rest, and it's quite commendable. Now, I don't know if I could ask again. Of course, you've touched on it, because I find you a lot of times as a defender of rights of individuals, which is a good thing, and again, as I say, I commend you for that. I don't know that those experiences have continued to influence your decision-making process, and also, of course, that also influenced your judicial philosophy, generally based on your personal experiences.
Yes, and to a great extent, but I'm also very balanced, given circumstances of the case. And that is why you can see I have a lot of experience in working for employers, local and international. I've served governments very faithfully in the Kingdom of Swaziland, here in Kenya, and at the EAC. I have really participated in developing key instruments for the East Africa community. So I have a sense of balance and of purpose, and to uphold the law in a purposeful manner. And so I have a balance, although I might accept that the context, the social context, is part of a judge's decision-making philosophy, impacts on the philosophy of the judge.
Yeah, that's right.
It's a fact.
Yeah. Now, Honorable Judge, I do not know now, what is your position regarding judicial overreach and judicial activism in development of jurisprudence?
In the context of Kenya after 2010, where we have specific articles in the Constitution, Article 20, Article 259, dictating to us to develop the law and dictating to us the values and principles which are part and parcel of our law, and we must take them into consideration as we interpret our law, and getting constitutional edicts that we must interpret the law to fill in the gaps to the extent that they do not uphold effect our Bill of Rights. Failing to implement those edicts and dictates is what I would call activists. Because we have an edict to develop the law, and in terms of as guided by the Constitution. So if you as a judge are not guided by those edicts, then that's what I would call activism, but in the negative sense.
Yeah, okay. The reason I'm asking, because I've seen very good decisions that you've made, which I agree with, and largely, I see somebody who wants to protect the rights of individuals. But again, I've also seen a situation whereby I think in arriving at a decision, you didn't consider the bigger picture, or where there was now judicial overreach. Not to criticize you, I'm just saying that when I look at the decision, and there's one case particularly that, because of course, even as we, prepare to interview candidates, you have to also do a bit of research to see the decision they've made. There's one decision that troubled me a little. The KNUT case versus the TSC. And in fact, when I look back, I remember that case was it captured the country because there was a strike and kids were affected, they were away and all that. But now, what I noted about that case, if I could just explain for just 1 minute, I noted that there was extensive evidence that was given in court where economists actually came and said that if you give the awards that the teachers were asking at the time, and we respect teachers and we don't want them to be paid well, of course, but if you give the award that they were asking for, the implication would be so big in the sense that it would affect our wage bill in the country would end up being 95.3% right, of our domestic revenue, because it would create a very huge disparity where it would affect also all the other civil servants. That would mean that our taxes would have to be increased. You can imagine 95.3% of the wage, of the consumption just going to wages. Now, you are told that it would also affect the pension liability, which at that time was, I think, 998 billion shillings. That in itself, the government will not even be able to, the country will not be able to afford. In fact, to me, when I was looking at it, it would literally amount to a national security threat in terms of the implications of the decision. Now, but in spite of all the evidence that was submitted by all these economists, by these specialists, you still ignored all that and went ahead and gave 50 to 60% award, notwithstanding all these warnings about what it would have in terms of implication in the entire country. In fact, you're even told there was even no budget for it. It had not been budgeted for. So it would also disrupt the budgeting process. In fact, you are told, before now you can answer, that you are taking over the work of 5 other institutions. You are taking over the work of Salaries and Remuneration Commission, Teacher Service Commission, Controller of Budget, Parliament, and the National Treasury. You became a conciliator, went ahead, and so all those issues. So I was just wondering, if you became now the Chief Justice and you are now looking at the bigger picture, you are looking at the rights, yes, of one section of the society, but ignoring the bigger picture. I mean, how would that work, if I may ask?
I do appreciate your analysis of that, but there was also evidence from the other side, correct? From the workers. And the history since 1997 of denial. Agreements reached, denial for years. Salary negotiations agreed, given in installments in 5 years. So there was compelling evidence also from the workers, from the teachers of this country, who at that time were earning from 15,000 shillings a month, a majority of them not beyond 30,000, 40,000 bracket. So we had the evidence from the economists. We had counter evidence from the workers. We had reports from SRC. We had agreements at 50, 60%. During negotiations, I actually implemented what had been agreed upon, but reneged upon after SRC intervened. There was already an agreement at 50, 60% by parties, both parties. SRC stepped in and they reneged on that promise. That was the context of it. And as soon as my judgment was injuncted by the Court of Appeal, they engaged into negotiations, which have resulted in salary increments in the same line I had decreed. In fact, I believe still today, were it not for that decision, this is whether it was nullified after that, the situation of teachers would never have changed. Immediately before even the matter was over at the Court of Appeal, they had already started implementing. And it was implemented, and it's a fact today, all teachers got between 50 to 60% salary increment thereafter. And there has never been a major strike by the teachers since then. And that was my focus. Because we had suffered, the children had suffered so much, the parents had suffered so much every day, every beginning of the year. there was a strike notice
but
for a
my
long period. So those are the facts which I took into consideration. I am not one to rock any boat. I've worked with governments for a long time. I've served the East Africa community for a long time. I'm very balanced. But I knew...
Actually, I don't have a problem with, taking decisions that are firm and all that. That's quite okay. I'm just trying to address the principles. It's so much about the principle, because when the matter went to the Court of Appeal, the Court of Appeal was of a different view. That's why I'm trying to follow that, because one, you became a conciliator, which the Court of Appeal was saying is against the Labor Relations Act. As a judge, you can't be a conciliator. You judicial overreach. The court said that you usurped jurisdiction you didn't have. You took over the work of other institutions. So basically faulting everything that you are saying that you did right. Now my worry is that you are taking a firm position that you are right in most of the decisions, even when the Court of Appeal is saying it's taking a diametrically opposed position to you. So would it then be a case of...
Can I correct you first?
Go ahead, my lord.
When the matter first went to the Court of Appeal, it was handled by a bench of none other than Commissioner sitting before Wasame as a judge of appeal.
Yeah.
In fact, at that interim stage, upheld the decision and directed that it be implemented. Another bench was constituted.
5-judge bench.
To counter the decision by Justice Wasame's bench. So there's no, even at that level, there was no unanimity on that matter. So that is why I say that I may not have been right because I was corrected. One bench of the Court of Appeal and partly implemented that decision, overruled. Yeah. The government itself implemented the same, if not better terms as those. That is the reason why we got into some sort of court-annexed side mediation with agreement of the parties. What? Because there was already an agreement before court, signed by the parties, but nullified by SRC. That was the basis. That is what gave me, that was what was informing me that why did it, I mean, on balancing of the facts, that was a main consideration. These parties had sat together for so many hours and days. They had hammered out an agreement. This agreement was about to start being implemented. And remember, there's a history of implementing these agreements in phases. That is what used to happen. They would agree on 50-60% basis. Yeah. Then they would then agree it will be paid in 4 years' time. So there was that history. And that is what was informing me. And I also had a lot of experience at Federation of Kenya Employers of hammering out CBA agreements. I have a great experience in this negotiating.
I agree with that.
It came from...
My worry, as I'm saying, is that you suddenly became now that conciliator who used to be at Federal Employees of Kenya.
Yeah, by agreement of the parties, and what I should have done, what happens in other jurisdictions was after that conciliation failed, in hindsight, I should have handed over the file to another judge.
Absolutely.
It happens all the time in other jurisdictions. Judges can step in and conciliate, which is actually a very good thing if it is anchored in law. But as soon as parties decide that you can step in and bring them together, as soon as that agreement fails, then you pass the file to the next judge.
Right. And that's what now the 5-judge bench, which...
in hindsight, that is what I should have done.
Chief Justice also participated in it, all observed. Anyway, that's okay, at least you accept that position. Now, my position is that, which is now leading to my next question, as the Chief Justice, what assurance would you give this commission and of course Kenya, because they're also watching, that if you made you the Chief Justice, that you'll be able to make decisions that always look at the bigger picture, because at the end of the day, it's a huge, huge position. It's not a small, you are heading the arm of government, where every single decision you make has national security implications. Not just on labor issues now, because now you are basically dealing with labor issues, but now you'll be dealing with bigger issues, where one single mistake could cost lives. It could cost, loss of jobs. It could cost, it can either make or break. You could make a decision that could either make, or you could make one that could break. So I do not know how what assurance you'd be able to give us so that as we retreat to decide with the Chief Justice, that notwithstanding other personal influences, I suspect probably the fact that your mother was a teacher could also have influenced you. I'm also influenced a lot by what happened to my mother as I grew up. We are all prejudiced, but you'll be the Chief Justice. I don't seek to be a Chief Justice. So I don't know how much assurance you'll be able to give, how you'd carry out your duties to ensure that you make a decision that look at the bigger picture at any given time.
First of all, our Constitution has got a lot of safeguards against impunity. There's no place for a dictator in our structure. Much more in the setup of the Supreme Court. There's no way as Chief Justice can have his way if it be unreasonable in that context. There's no room for a Chief Justice to stand there and pontificate on constitutional and unlawful endings. Two, right from the university when I was gotten to steer, to bring peace within this in very turmoil, difficult situations. And I was able to anchor the university through a very difficult period. And all the students from corners of Kenya trusted me to do that as a very young man, and I did. Expelled, not even a disciplinary hearing until when I left. And as soon as I went to School of Law, before 3 months were over, we had another one of the most violent elected.
Yeah. Okay. Now.
So, I am very safe hands. I have balance. I have a lot of balance. And those who have worked with me, especially at the East Africa community, including Justice Kihara, the Attorney General, who was my chairman of the East Africa Judicial Education Committee, where I developed many concepts to train judges in East Africa. And I actually delivered many trainings in all the 5 East African countries. Raising funds, developing proposals and concepts, getting funds from development partners, initiating training programs here in Kenya, Uganda, Tanzania, Rwanda. Justice Kihara as my chairman, representing the nation of Kenya. I have a lot of commitment in what I do. I have a lot of patriotism beyond, and that is why I had to come back, even when I had very good position down there in Swaziland.
I thank you for that,
Absolutely.
my Lord. I thank you for that. Now, you mentioned...
And lastly, one which I forgot to mention in my CV, which you have, is that in 2010, when the referendum process leading to the promulgation of the Constitution was challenged in the interim constitutional court by organizations which felt that that process which birthed our constitution was not fair and just, and they lost their case at the interim constitutional court, they filed a reference to the East African community. They filed against the Attorney General of Kenya and against the Secretary General of East Africa community, saying that the process which led to the promulgation of our constitution and violated not only the laws of Kenya and also violated the East Africa Treaty. I was again called upon to lead the defense of this country in that case, which is in the first page of the East Africa Law Report. You've seen it? I led that defense of this country.
My Lord, your CV is impressive.
And we succeeded to defend the detractors of the promulgation of our constitution.
I don't doubt your CV. It cuts across. I mean, it's really, you are widely exposed. That I have no doubt. Now, you mentioned something about the process of disciplining magistrates not being very clear. It's not, if it's there, it's not, you know, I think I'm just quoting your words. You said that if it's not there, you're not familiar with it. But I thought it's quite comprehensive under Schedule 3 of the Judicial Service Act, because it's very comprehensive about all the steps. Maybe application is not being applied correctly, but in terms of the steps, I'm not sure whether you are aware about it, just as a matter of clarification.
During when I dealt with the case Commissioner Judge was dealing with, in for the and I'm aware there's so much in the manner they are handled, especially in terms of timelines within years. I had a colleague in Kisumu who I think had waited for 3 years.
I appreciate that there's no
it's not
process.
What I'm talking about. I would want to do is to have the same way you have some simple documents developed and given to people with very precise and detailed of the expectations and steps to be taken and timelines that if should a magistrate be suspended pending investigation, blah blah blah, this must be done this way within this timeline, and should it not happen, this should happen, this should happen. In other words, I'm not looking for another regulation. I want to champion development of documents, simple documents with the people, to be with us internally, to understand those processes, and so that if they are violated, we can say that why is a magistrate waiting for 3 years without pay?
I agree with you. I agree with
without
you, my lord,
pay.
on that. We agree with you. Now, the final point on that, I also had you mention that you talked about if you became the Chief Justice, you emphasized so much on the judges and the magistrates, but I didn't hear you talk about the support staff, who are a critical component that is normally ignored. And sometimes I get the impression that even as judges and magistrates are talking about themselves, they don't seem to appreciate that these enablers, the support staff, as important, because their work will also determine how effective the judges and magistrates, will be able to do their work. I would also like to hear a bit, about that.
Yeah, thank you very much for that. Was an omission on my part, and actually prepared myself on it because I'm very passionate about every staff member. I'm aware of the directorates and the staff who serve below them at the lowest level. And I also looked at their levels of satisfaction in the report, which were not bad. The percentages in that cadre of disaffection, some were very high, of satisfaction were very high. And that's why I did not become very concerned, because if I'm to be guided by the that report, if it speaks the truth, it appeared to me like there was a very high level of satisfaction within the administrative cadre. And but it's an area I should be able to interrogate and to follow upon, because I believe that if all the staff or any of the staff they are disgruntled, their issues are not being handled, especially the sanctions and the rewards. Another area I would want to talk about, for example, who knows what criteria is used for staff in the judiciary to be given national honors? Who knows which committee and who deals with it? I know there is one, but do we know? Do we know why some people have received 2 commendations from the president and others don't have one within very short timelines? Is it that the others are not deserving? Who deals with it? What is the criteria? Can we have a small booklet of 2 pages telling us this is a criteria of receiving state commendation as a judicial officer, as a magistrate, as a staff for the work you have done? These are the areas of disaffection where people quietly, because judges have no room to go out there and make noise. But it doesn't mean that they don't feel it. They're not they don't feel it. They can see, and they don't know why this, not why that. But so what I advocate for is a transparent edicts, little procedures, transparent saying, this number of judicial officers have been honored by our president, and this is a criteria which has been used, and in the future, this is a path we are going.
Wish you well. That's all for me.
Thank you.
Thank you. Thank you, Commissioner Jero. Your Honor, we will take a short break.
Appreciate it.
5 minutes. We'll come back, Honorable Commissioners, at 12:15. It's about 10 minutes.
12.
Thank you.
Okay. Yes, yes.
Tamasha Paints, rangi
siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongeze zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Ndio vile nitaongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo double.
Raukia siku njema na tunukiwa ofa kila siku.
Welcome to Nairobi Christian Center Bahati. We are an Assemblies of God Church under Reverend Fred Gitahi as a senior pastor. We are located at Bahati, Makadara area in Nairobi. We run a virtual church service with online services every Sunday at 8:30 a.m. and 11:30 a.m. as well as the children's services from 10 a.m. services every Saturday at 11 a.m. and 2 p.m. respectively. You can follow us on Facebook and Instagram at Nairobi Christian Center Bahati and on YouTube Nairobi Christian Center. Be blessed.
On the next episode of The Cook-Off Show with Alex Karani.
Welcome to my show. This is the cooking show where we just
come slowly. Wenyewe walisema ukweli. Wenyewe wanawake wanakuwa na maneno mingi. Sasa umeanza busi, umeanza kisho ya busi de ule busi de. You ready?
Wait a minute. Mimi uliniambia nikuja nichemshe kichwa busi alafu mnanipatia hizi vitu gumu na kwa kitu ya maana nafanyaga nini?
Shika hapa. Shika hapa.
Unadhani nitaweza kumultitask?
Siwe tunasikia kama demo multitask.
Mimi sio madem.
Saveri.
From a distance.
Don't. Please. We were acting. Wacha mimi niendelea kukula. Wacha endelea kunini.
Wewe endelea tu kukula.
Kuongea. Mimi unajua kukula ndio ilikuwa imenileta. Niliwaambia welcome to my shop where we just eat. Cooking is none of my business.
People to see farming as a possibility and not you don't concentrate your energy, your efforts into one. We enrich our soil so that we can produce more healthy crops which are naturally good for the people.
Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. Next episode of Coffee with the Movie.
Ladies and gentlemen, today I have that singer, inspiring man of God, Sifa Favor. Karibu man.
Karibu. But I'll be honest with you, I bought my first land when I was 13, half an acre.
How much was half an acre at that time?
Nilipigwa until the joints were not moving. Even the legs were not moving.
I think coming on stage.
Catch this story every Sunday at 8 p.m.
In the next episode, we head to Kayole and speak to Nancy about animal feed.
There's this slogan in the Finidia.
On Monday, 7:30 p.m.
Clean.
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongeze zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Nitajua vile nitaongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo Double.
Raukia siku njema na tunukiwa offers kila siku.
Welcome to Nairobi Christian Center Bahati. We are an Assemblies of God Church under Reverend Fred Gitahi as a senior pastor. We are located at Bahati, Makadara area in Nairobi. We run a virtual church service with online services every Sunday at 8:30 a.m. and 11:30 a.m. as well as the children's services from 10 a.m., teens and youth services every Saturday at 11 a.m. and 2 p.m. respectively. You can follow us on Facebook and Instagram at Nairobi Christian Center Bahati and on YouTube Nairobi Christian Center. Be blessed.
On the next episode of The Cook-Off Show with Alex Karan.
Welcome to my show. This is the cooking show where we just eat.
Come slowly. Enyewe walisema ukweli. Enyewe wanawake wanakuwa na maneno mingi. Sasa umeanza busi, umeanza kisho ya busi. Kwani yule busi de. You ready?
Wait a minute. Mimi uliniambia nikuja nichemshe kichwa busi alafu unanipatia hizi vitu gumu na kwa kitu ya maana nafanyaga nini?
Shika hapa.
Unadhani nitaweza kumultitask?
Siwe sinasikia kama mademu multitask.
Mimi sio mademu.
So very. Ni chita kweli?
Ni kama la dongoro yame.
From a distance.
Don't. Please. We were acting. Wacha mimi niendelea kukula.
Wewe endelea tu kukula, mimi nishamaliza.
Endelea kuongea. Mimi unajua kukula ndio ilikuwa imenileta. Niliwaambia welcome to my shop where we just eat. Cooking is none of my business.
People to see farming as a possibility and not as impossibility. You don't concentrate your energy, your efforts into one section of the farm. We enrich our soil so that we can produce more healthy crops which are naturally good for the people.
Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. Next episode of Coffee with Movie.
Ladies and gentlemen, today I have that singer, inspiring man of God, Sifa Favor. Karibu man.
Karibu.
Mambo.
Asante sana. But I'll be honest with you, I bought my first land when I was 13, half an acre.
How much was half an acre at that time?
Nilipigwa until the joints were not moving. Even the legs were not moving. Even the head, I think niko na alama.
Most embarrassing moment when you're performing on stage.
Catch this story every Sunday at 8 p.m.
Episode, we head to Kayole and speak to Nancy about animal feed.
There's this slogan, inafinyidia biashara sana. Customer is always right. My God.
On the Grind, Monday, 7:30 p.m.
Let's go beyond.
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongeze zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Nitajua vile nitaongea na kila mmoja wao.
Very good. Piga *444 hashi utunukiwe Credo Double.
Raukia siku njema na tunukiwa offers kila siku.
Welcome to Nairobi Christian Center Bahati. We are an Assemblies of God church under Reverend Fred Gitahi as a senior pastor. We are located at Bahati, Makadara area in Nairobi. We run a virtual church service with online services every Sunday at 8:30 a.m. and 11:30 a.m. as well as the children's services from 10 a.m., teens and youth services every Saturday at 11 a.m. and 2 p.m. respectively. You can follow us on Facebook and Instagram at Nairobi Christian Center Bahati and on YouTube Nairobi Christian Center. Be blessed.
On the next episode of The Cook-Off Show with Alex Karani.
Welcome to my show. This is the cooking show where we just eat.
Come slowly. Enyewe walisema ukweli. Enyewe wanawake wanakuwaga na maneno mingi. Sasa umeanza busi, umeanza kisho ya busi. Kwani yule busi de. You ready?
Wait a minute. Mimi uliniambia nikuja nichemshe kichwa busi alafu mnanipatia hizi vitu gumu na kwa kitu ya maana nafanyaga nini?
Shika hapa.
Unadhani nitaweza kumultitask?
Siwe sinasikia kama demo multitask.
Mimi sio madem.
Mimi
nijificha.
Ni chita kweli?
Ni kama la dongoro yame.
From a distance.
I don't. Please. We were acting. Wacha mimi niendelea kukula.
Wewe endelea tu kukula, mimi nishamaliza.
Endelea kuongea. Mimi unajua kukula ndio ilikuwa imenileta. Niliwaambia welcome to my shop where we just eat. Cooking is none of my business.
People to see farming as a possibility and not as impossibility.
Of states, and that's because that is how we developed documents at the EAC through consensus. And so I know that heads of states do not deal with issues which have not originated from senior officials. A head of state wants to be confronted with an issue which has been mooted, discussed, issues narrowed, honestly and transparently from both sides. And I know the role of mooting that concept and bringing, narrowing the issues before they are presented to the head of state, who must eventually resolve this issue, must come from his very senior officials, some of whom this JSC is representative. And I believe some of the most critical senior officials to unlock are right here with us. And those are the ones that will engage immediately so that we come up with, within a very short time, with a framework which will narrow the issues so that we can even have talks about talks and agree that this is where we are. This is what judiciary is saying. This is what the president, the executive is saying. This is what is wrong. This is what is right. This is what is possible. And then we say, we are ready, let's go to the president with those issues. That's how heads of states work. They are too busy to be confronted with issues which have not been narrowed down. If you do that, you're bound to fail. So I, as a diplomat by excellence, I know how to deal with that. And I know how I will unlock it within a very short time. I know there's goodwill to do that, and goodwill is cultivated, it's built. It doesn't just come, you can't take it for granted. And that's part of a critical part of leadership, which I believe I am very strong in, Commissioner.
Thank you. And on the aspect which you also touched of these cases which are haunting judges and magistrates before the Judicial Service Commission, you gave us a recipe of what should be done going forward. How would you deal with the current backlog within the JSC so that what is pending is dealt with expeditiously?
I wish I was aware of the extent of the backlog, and that's an issue I will interact with immediately if I was appointed. But for a fact, judges are hurting, magistrates are hurting. The critical mass, our people of Kenya, may not have the correct information about this issue. The satisfaction index percentages about the service they are getting appear so good when I look at the 2019-2020 report. So therefore, why should our judges be so haunted that they have to take so much of their time to defend matters which, because of the decision they make as judges? Why don't we have, in the shortest time, a criteria to thrash out those issues and allow judges to do their work? At the same time, communicate effectively to the people of Kenya that the independence of a judge is central to the dispensation of justice. And if that is threatened and eventually defeated, there'll be just anarchy. You cannot have judges having to look this way and that way to decide a matter because they're so afraid that tomorrow they will be before the JSC. We are getting to the point where judges and magistrates have to consider, do I make this decision? Because this party appears so confrontational that I'm almost sure that tomorrow I'll be before the JSC. Should now that become a consideration? It will be the end of the judiciary. We are about getting there, believe you me. And I would want, as soon as I am the CJ, to interact with the honorable commissioners. I'll be appraised on the pending issues and then determine those which have to do with the decision of making. Independence of a judge must be dealt with quickly. If there be matters of misconduct, serious misconduct, then we also expedite them. But issues touching on decision or independence of the judge are a threat to the dispensation of justice in this country. They will lead to anarchy. Remember the history of the judiciary, the star chambers in Europe, where judges were hanged because they made decisions. That is the history of judiciary and how independence of the nations decided that this institution must be guarded and defended so that it can be able to dispense justice to the people. We cannot afford to lose that. Thank you.
Thank you, my lord. Speaking of independence and the delegation of sovereign power, what would you consider to be the role of the other two arms of government in protecting the independence of the judiciary?
First of all, the three arms of government are interdependent. There cannot be a government without the three of them, and all are born of the people, and they serve the people. We serve a common purpose in different roles. The authority we have at all those three levels is from the people. So there is area of commonality, and therefore, when decisions of the court issued fairly and justly, whether you agree with them or not, as an executive, please obey them and appeal. And because continued disregard of court decisions eventually leads to anarchy. And anarchy comes slowly, slowly without knocking the doors. Issues of finance, financial independence of the judiciary, to unlock, and therefore the parliament is there to facilitate this institution, to foster create unnecessary conflict. We are interdependent and we must allow, and all of us born of the people. So let Parliament do its work. Let the county assemblies do their work. Let the judiciary do its work. And let us intervene as and when it is necessary in terms of the dictates of the Constitution. We have been very well guided by the Supreme Court judges in that respect. And so everybody must read the Karaoke Mate case, and the edict by the Supreme Court and the doctrine of judicial restraint. Then there will be harmony from our side.
And where would you place judicial activism in the development of the jurisprudence of the Supreme Court going forward?
As I said earlier, Honorable Attorney General, the Supreme Court is bound to implement the Constitution as is and to interpret it in a purposeful and harmonious manner without one part destroying the other. And the Constitution also has guided us in areas where we can fill gaps using the principles and values in the Constitution. So we're very well guided so that whatever gaps may be there, they have been, a question of activism does not arise. In fact, a judicial officer who does not want to obey the constitutional edicts is the activist, in my view, in the negative sense, because this Constitution was born out of sweat and blood, and we are bound to implement it as is, and we are very well guided in that respect in that document. So I do not see any danger in any Supreme Court judge deviating from that framework of the Constitution.
And finally, my Lord, why has the judiciary failed in the fight against corruption?
Again, I was very surprised again when yesterday I went through the court users report 2019-2020. And I was actually, it is with me here, I focused on that area of corruption. And the report focuses on corruption in the magistracy, corruption in the High Court and all superior courts, corruption in procurement, that's a directorate. I was so surprised, like within the procurement directorate, the level of satisfaction was 90% and above, in fact 92%. Unless there's something wrong with those, the manner the surveys were conducted. I was astounded because this perception there is that this place is completely corrupt. When I looked at the corruption indexes regarding magistracy, again, the satisfaction levels are over 70%. The same with the judges. Then I was asking myself, as I was preparing to come before you, where is this perception, which actually is so strong there that this judiciary is burning of corruption? When surveys are conducted and they seem to be saying something different. Given that, a 1% corruption is not acceptable in the judiciary. And so the proposals, the frameworks, the measurement, the accountability framework, which we have put in place, and is within 2019, 2023, plan. Those frameworks, they're very good framework, steps in curtailing, in enhancing accountability within the judicial cadre, within the procurement area, and especially at our registries, because I saw the largest, the highest level of dissatisfaction was in the manner and the timeliness within which court users are treated within our court registries. That is where the highest level of dissatisfaction and is expressed, and therefore construed to be corruption is. So we give special focus, being informed by the survey, to have specific initiatives of accountability, working with the right directorates to enhance reduction of, to reduce, first of all, the corruption itself, and more so through the interfaces we have, the court users, the open days, every interface we have with our people, to educate each other on what we are doing, and so that they may also be fair to us as an institution which serves them when they judge us.
So if I understand you correctly, my lord, according to the statistics you've looked at, there is no corruption in the judiciary. But to use your own words, there is a perception, very strong perception out there, that the judiciary is rotten with corruption. So how are you going to engage out there to disabuse that perception?
Exactly. A big headache, because perception coming from years of a very non-responsive judiciary.
It's a big headache, yes. It's your headache now. You're the Chief Justice. What are you going to do?
First of all, whatever percentage of corruption is there must be dealt with very firmly. And again, synergies. We have our internal department of accountability, PPMU, and the framework they have developed is very, very key. All I'll do is try to enhance it. We shall have synergies, working interface with DCI. We shall interface with EACC and all other agencies which are concerned with transparency, Commission Human Rights, all organizations concerned with the issue of corruption, transparency, accountability. We shall engage them and engage them and help us to develop, first of all, to communicate out there and develop.
But Judge, with respect, this has been done over the years. This is what the judiciary does. But the problem doesn't seem to be ending. What are you going to do differently to ensure that you get a result that erases that perception? Because if you look at the history of the judiciary over the years, Chief Justice after Chief Justice, but we still keep saying the perception is still there. To use your own words, it's very strong. So what is Chief Justice Nduma Nderi going to do so that in the course of his tenure we can sit here and say that perception no longer exists or has been reduced substantially?
Chief Justice Nduma will not raise his hands and give up. I will say again that I have studied the initiatives which are in our plan, strategic plan. I have seen what has been done. I have seen the challenges which have been developed. I will enhance the communication the interaction, the communication, how we communicate, and especially I believe through radio programs, because I think that reaches the greatest number of people. So we have to find better and effective ways of communicating to our people. How you cannot say that I appreciate the social media, but to how many people does it reach? I know the elite are all there, but we need to communicate to Wanjiko. I'm usually very impressed by the radio talk by the head of state of the United States of America. They usually talk directly to the people through radio, and it is still the most effective way of reaching to the farthest corners of the country. I want to come up with programs which will reach the largest number of people, but remember, we must be vigilant on whatever percentage is there on corruption. We must deal with it consistently by improving our measures which will stop any form of corruption, despite how small it is. At the same time, we'll continue getting feedback from the public, but I want our communicators to develop more and frequent and focused messages, especially through radio to the people of Kenya, and in Kiswahili, and even in mother tongue to the people. I believe our communication with Wanjiko has not been effective, and that is the only way. There's no magic word, but it can be done. I will do my part.
Thank you very much, my Lord. Honourable Madam Chair, that's all from my side. Thank you very much.
Thank you very much, Honourable AG. I will now request Commissioner Gishohi to please ask your questions, Commissioner.
Thank you, Chair. Judge, good afternoon.
Yes, good afternoon.
Yes, before we go down to the lines that I'm assigned to, I would like from you, you have spoken very passionately about the institution. Yes, you can take the water first.
Sorry, I think.
Yes, just open it through the chair.
Thank you.
Good. You have given us a long journey, your experience, your career, all the way from the university down to the Kingdom of Swaziland, East African Community, FKE, and also here. I want you to share one lesson, just one lesson through that journey that you have learned that prepares you for the position of the chairperson of this commission. Just one lesson that you have learned that prepares you for this position of chair of the commission. What lesson have you learned? One. But I want you to focus as the chair of the commission.
I think the biggest attribute of a good chairperson is respect. Respect of the members of the committees they chair. Two, to be prepared every time when you sit as a chair of the meeting.
Okay.
So that you appear all the time to be in control and knowing what you're doing. And three, you must develop friendships. All the time, with the people you work with.
Okay.
Yeah.
Let's take that. Then I would like you also to, I'm sure when you are preparing for this interview, you had a look at the documents that we have for all the issues, and your position as a judge also. The key areas of concern, I'm sure you talked about the disciplinary part, that you are not very satisfied with the process of discipline in the commission. Apart from that, which other areas would you address as you come in as a chair of the commission? As it relates to the commission, which two other areas would be of concern to you and you'd like to address them? Two areas.
I would really, thank you first of all. I would really want to help and work with the commission to enhance their ability to mobilize funds for education of judiciary staff and judges and the magistrates, because I recognize that is a core mandate of this commission, and I've already spoken so passionately about it. So I would really want to engage and work with the commission so that we are very focused in, first of all, in developing helping JTI to develop programs, to mobilize funds, and to conduct training needs analysis, so that we just don't do training for the sake of it.
Very good. Let's take the case of staff. Efficiency, productivity is very key for public service. Efficiency, productivity, service delivery. What strategies do you put in place? Two strategies that you put in place to ensure that we increase our efficiency, productivity, particularly on part of staff. Two strategies that you'll be able to put in place to increase the efficiency, productivity on the part of staff.
First of all, I must recognize the strategies in place already. There are a lot of work done, because I have looked at what, first of all, the directorate, I don't remember the PMMU, the measurement and accountability department has the frameworks which are in place for ensuring that, measurement of individual productivity, group unit productivity. I think for me, it will be a matter of really upscaling and continuously updating and enhancing use of technology in whatever they are doing, so that we have accurate data, friendly methods of making sure we have a true reflection of work being done. Two, the reward and sanction mechanisms also need to be very transparent. I already touched on that. I would really focus on that, because I know recognition is, I have a HR background.
Okay.
Recognition works much more than even the salary in ensuring productivity of employees.
The Honorable Attorney General did allude to this, and I want to refer you back to it. In terms of the surface you have looked at and the statistics that we have, in the last 10 years, the population within judiciary, in terms of staff, has increased by almost 65% in terms of the population, almost 65%.
So pardon me, what has increased?
The staff.
Okay.
In terms of all the cadres, including judges, magistrates, and the staff. And also, to some extent, the budget that we had in 2010 or 2011 has also increased. Not so much, but it is reasonable. And you read about the surface satisfaction, but the Kenyans still are very much concerned that our service is below expectations. That's the reality on the ground. That the service that we give the Kenyans is still below expectations. I want from you, Judge, particularly coming from this Court of Employment, Labor Relations, and you are the chairperson of the Commission, to be very clear as you share the Commission, what we need to do, apart from that survey, what have we missed? What do we need to do different to ensure that our clients, the public, get some reasonable satisfaction in terms of our work?
That feedback, Commissioner, we get as a judiciary on the levels of satisfaction, the output, our work, especially the manner we are able to conclude cases from filing to judgment, and in other areas where we are giving service to the people. That's those. The demands we're getting from the public are not, there's the good and the bad of it. Remember, under JTET, the Mutunga program opened up the judiciary on levels of transparency and accountability never experienced before in this country. And I believe the judiciary, if well judged, is the most open organ of government. That is double-edged because the more you open up and you are clearly delivering much more than you've done before. So the level of expectation grows with that, and rightly so. And what we need to do, as I conclude, is that we need to continue doing the good things we are doing. If you expect one day to be told, finally you have arrived, it will not happen.
Okay. So if somebody appears in your court tomorrow morning on a new issue, which is the earliest date can you give that person in terms of maybe his case to come? How soon? Right now? In my specific court now at Milimani, remember I've just been come from Kisumu to Milimani, and first of all, we are not giving dates for matters 2018, 2019, 2020. You cannot get a date. That is how bad it is. We are only giving dates for 2014, 2015, and 2016 matters. So what does that tell you? I remember under the SJT, we cleared almost all the 2014 cases. And we had embarked on another rapid initiative to clear the 2015, which I think will be my focus. Now, another rapid initiative through different methods to now focus on 2015, 2016 cases. This is the same in Kisumu, where I was for 3 years. We have 2014, 20 now. I think 2014 is almost gone. It is gone. 2015 almost gone. We have 2016, 2017, 2018 matters. Okay. Which there they have dates because there is no restriction. In Nairobi, there were notices from the principal judge that you cannot get dates for these years. You have to wait because we are dealing with these other cases. Okay. So it's that bad. 6 years old there? Yes. You're talking about efficiency. Let's move on to something else. I want to look at financial. You talked about financial and funding. Kenyans believe under the Constitution, we should be able to fund the judiciary from our taxes to some extent. What as a chairperson of the Commission, accountability for the funds that you are given is very crucial. What kind of mechanism would you put in place? And here I want you to be aware of the Constitution, the various statutes that we have that govern our financial structures and governance. I want to hear from you as a chairperson of the Commission. That top, you are the head of the Commission, the accountability mechanism that you put in place to ensure that the funds that we get are properly accounted for and used. Accountability mechanism. 2 or 3. As a share.
First of all, the expenditure of funds in whatever area in government.
No, Judge. I want us to focus. You are the judiciary, the chairperson of the commission.
Yes.
My question is very specific.
Yes.
Accountability mechanism that you have to put as you manage, or the funds are managed, because the board stops at you. As those funds are being managed, what mechanism do you put? Maybe it be personnel, procurement, all those issues. I would like to hear from you at least 4 mechanisms that you can put in place to ensure that you're in charge of those funding.
The one immediate one is that once funds are received from Exchequer, I, as the head of the judiciary, knows and have received reports. I'm aware of our budget and what the money has been allocated for, and I know the specific areas where money has been allocated for. So my first responsibility is to ensure that, first of all, money which has been allocated to us is absorbed and used. 2, to ensure that I have the tabs on how the money is being used. I expect feedback from the finance chief registrar, which I expect to have channels of feedback and reports on procurement.
Share with us those reports that you expect to get from the accounting officer, and you don't do the work of the accounting officer. Share with the commission what kind of reports that you expect to get from your accounting officer as far as the management of those funds are concerned. And I see it across the board: procurement, personnel, all the rest.
First of all, a report on procurement, what has been procured within a specific period. There must be a report to me matching what the requisitions, whatever we had planned to do with the money. There should be an audit reports also.
Audit reports
at the internal level, which must come to me to make sure I am in touch and with the manner in which expenditure is being used.
Okay.
The other one is that
are you familiar with the financial management within government, within public service? That's my question, the bottom line.
Yes, I have the frame. I know we have the act and the framework which is in place for monitoring of use of funds and accountability, and especially the report which finally must go to Parliament on accountability.
Let's move on. Releasing those funds, and I want us to remain focused to your position, to your role as the chairperson of the commission. And you need to secure funds for judiciary. What role do you play in terms of making sure that judiciary, including the commission, gets adequate funds from the various arms of government, particularly the 2 arms of government that are responsible for the government funding process?
First of all, the Chief Justice must have a very constructive interface on issues, finance, and our requirements, even at the level of the head of state.
Interface with the head of state?
Yes.
In his capacity
as a head of the nation, as a president of this country.
Very good. Then the next interface?
The next interface is with the hands of with the exchequer. I mean with the CS Treasury.
CS stands for what? CS?
Cabinet Secretary.
Treasury, yes.
Treasury.
Very good.
The other interface is with the Speaker of the Senate and the Speaker of the National Assembly.
I want you to break down the Honorable Speaker's offices and share with us the organs within that legislature that are very key to make sure that we get our funds that we require.
We have two key committees, which is a committee on allocation of finances.
Appropriation committee, we call it, yes?
Yes. We have the committee dealing with judicial and legal matters.
Judicial, yes, very good.
Yes.
We have had this judiciary fund for some time, and we have been trying to make sure that the judiciary fund is actually established, realized, and getting funds in that fund. We are here to get the position as the chairperson of the commission. What steps do you take to ensure that the fund is up and running? The judiciary fund, which is in the constitution.
The act is in place.
Yes,
if
it's
I'm not wrong.
It is in place.
The regulations have been developed.
They are in place.
They have not been implemented.
So what do you do to have it implemented? Two things you will do to make sure it is implemented.
Again, I believe the office of the Attorney General has a role to play in that. The Parliament has a role to play with that, and it will be part of the agenda, the robust agenda we'll have with the hands of with the AG's office and Parliament to ensure that fund is in place.
Okay. What will be the role of the office of the Honorable Attorney General in that process?
First of all, Attorney General sits in Parliament. I don't know whether Attorney General has a key role in the development of whatever regulations and registration in Parliament.
Are you sure he sits in Parliament? Does he sit there?
He doesn't sit now, I think, but I think he has a key role in guiding development and implementation of regulation, including gazettement, and making sure that it is done. So we have solutions within and without there. And as the Chief Justice, I think I will seek, first of all, I'd want to understand the issue much more.
Okay.
And I would have that opportunity once.
So, Honorable Judge, and that's good enough for me. I want us now to tackle a different issue altogether. And this is specific to your court, the Employment Labor Relations Court. What is the role of that court as far as economic development is concerned, Vision 2030? Does that court have any role in terms of realization of Vision 2030? That's your court, Employment Labor Relations Court. Does it have a law, and if so, which one?
Labor is a key component of that is human resource. It's a key component of, in fact, the center of any development initiative. Without people and with proper legal frameworks and which are properly interpreted with certainty, and that is a key role of our court to interpret the laws in place in a just and consistent manner, so that there is certainty in what investors expect is certainty of the law and outcomes before they bring their money into any particular country. I believe the Labour Court has got a key role in ensuring that jurisprudence which guides labor is well understood by potential investors, is just and fair, and that is what we should continuously make sure so that the country attracts direct and indirect investment.
Okay. What is the turnaround of cases in the court? You know, this is very crucial because Vision 2030, when it was started, people thought it was a very far off vision. We are maybe 9 years before we come to 2030. We are going to have a measurement in terms of your court and the realization of that goal. I mean, where would you place yourself? You have spent almost of your time. Where would you place yourself? Are we anywhere near? As you address that, I want you to address the turnaround, particularly for disputes that between employer and employees that are supposed to be unlocked to ensure that we realize our goals.
Yes and no, because the turnaround period of cases in E&LRC depends on the age of the station. Remember, this is a court which has been slowly enrolled. I mean, it's being stations being,
on average. Let's take on average.
So out there in specific stations, it takes months. Kericho, Eldoret, Nyeri, it takes only months to clear cases. Go to Kisumu, Mombasa, Nairobi, it takes 3 years. So we have 7 court stations, and we have now 11 substations where we are hopefully we will become Chief Justice. They will soon become fully French courts. In those stations, they don't even have enough work. In Kisumu, Mombasa, Nairobi, I will have a strategy. And I've just said that we are dealing with 2016, 2017, 2018 cases. If we are focused in clearing that backlog, obviously the new cases are ignored. And so the case clearance measure is very poor in those stations where we are focused on the old cases, because justice dictates that we deal with the older cases first, and therefore we ignore the new ones. And so we appear to be stagnating, because it is good that we lead off the back. But if you find you're dealing with 2016, 2018 matters, then it's a problem.
I want us to go to something else, and this relates to the United Nations Sustainable Development Goals. And I'm sure you are aware about it. And I want you to focus on goal number 8 of the SDG, particularly where we have equal pay for work of equal value. And also making sure that employment and decent work for all in safe and secure working environment. How does your court ensure that that particular goal is realized and protected as you continually do your work?
The decent work agenda developed by the United Nations has been mainstreamed in our legal and cooperative frameworks in Kenya already. The core conventions which guide the principles of equal pay for equal work have also been mainstreamed in our laws.
Very good.
So if you look at various provisions of our law, they are there. It's a question of implementation, and for the court is to make sure those provisions, and especially the constitutional edict under Article 41, which especially touches on that issue, fair remuneration for all, equal. It's just a matter of implementation.
Okay, you are actually able to answer this question, Honorable Judge, and it's not anywhere within my write-up here. Earlier on, you talked about making sure that you protect, promote work, particularly as it is to women, girls, and the rest. Do the boys child have any place in your...
I'm very, very concerned, I know, like every Kenyan, with the boy child. appreciating how much we love our mothers and sisters, and so much effort.
I've not heard anybody talk about fathers.
Nobody talks about them. Really, I know this is a real concern now, even for the mothers. They are becoming now more concerned about their boys than we are. And I believe there will be very, sooner than later, we are going to have both our mothers and fathers working together to further the protection of the boy child, because he's really under siege.
Very good. Just before I end up, devolution, which is very, very key in our governance structure. If you get this position of Chief Justice at the head of judiciary, and you happen to be invited by the Council of Governors, who are very concerned about the level of justice in their various counties, what two things would you address them as far as judiciary is concerned? If the Council of Governors pays you an appointment as the Chief Justice, they are out there in the 47 counties across the country, would you share with us two things you would be able to let them know that we need to do to enhance access to justice in our counties? Two things.
The first issue, which actually is in my imagined blueprint as the next Chief Justice, is upscaling all the ICT pilots.
ICT?
Pilots. And I want to use a devolved model. The only way to upscale our pilots, which are this automating court processes, which is working now, I believe, at the Supreme Court and Appeal Court. That, especially that particular aspect of freeing the hand of the judge from writing, which Commissioner, in my 8 years as a judge in the little kingdom of Swaziland, I never did, because the courts were already automated as early as 1990s, which I never did at the EAC, because where we send our judges and they sit there.
I want you to focus to the audience. Your audience is the Council of Governors.
So I will deal with how the Council of Governors will help us to develop, first of all, our Mahakama centers.
Mahakama centers? These are called centers, I presume. Eh?
Absolutely, because already we have done so well with the other, what are they called? The centers of service delivery in every county. I would want to focus specifically on the issue of land allocation in the counties where we don't have land to build our courts, because we have an edict, a constitutional edict, to have a high court station in every county. So that will be an issue for me.
Land allocation.
Land allocation.
Next one.
And facilitation, cooperation in the upscaling of ICT solutions in our courts in every county. I believe they have a very good experience, because within a few months, all the county assemblies had Hansard systems implemented within months.
Finally, Madam Chair, Judge, I alone talked about issues of internal controls. I'm aware that you have the Judiciary Leadership Advisory Council. This morning, I did try to look at the membership of that council and the functions of that council. Are you familiar with that council internally? The Judiciary Leadership Advisory Council?
I sat with it.
You sat on it?
All the time I was the principal judge.
Up to 2017?
Yes, up to 2017, yes.
Then if you sat in that council, which one will take its internal cabinet? the one that is supposed to address all these issues we have talked about, discipline, and you actually said about Honorable Judge Wajara's committee that was taking the issues regarding judges. One gets a little concerned. Is that council, is that internal mechanism working? And if so, how effective? If not, why?
It is an advisory organ. Advisory.
Advisory to who?
The members of that committee, comprising of the heads of courts, the principal the presidents of the courts, the principal judges, the deputy chief justice. We advise the chief justice. Everybody comes there to advise the chief justice, who sits in all other arms of organs of the judiciary, especially this JSC, so that when he comes as the chair of JSC, he has inside information as he comes to sit with you. So we give you, we would have thematic papers. I would, for example, as a principal judge of the employment and labor, come up with a paper, table it there for purposes of advice and feedback on the concerns.
So how often does that council meet? Because from what you have said, Honorable Judge, this morning, a lot of things this morning that you said, one gets the impression either this council is dormant, the council is not working.
I am aware that left in 2017. I am aware from reliable information from my principal judge that they have only met once.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. Now is the turn for Commissioner Koskei to ask a few questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yeah, I've been listening carefully since morning, and I realized that you reflected a lot on how judiciary should be run, what is obtaining on the ground, and the possible improvements that needs to be done. And I wanted to know from you, looking at judiciary, that we can be run differently to enhance efficiency and effectiveness. And you can give us about 4 areas: 2 judicial side and 2 administrative.
Thank you very much.
And also why? Why are you?
Thank you
why
very
do you think
much.
that is what you want to do first? Yeah.
Okay. I believe in my already I've alluded to some of those areas. I have key concerns in the area of promotion of especially the staff and the magistrates.
Yes.
A framework which is known and accessible.
So staff matters you need to sort out.
Yes, and in the same vein, I had talked about within the staff, the discipline, transparency. I'm very, very concerned about the fact that in a medium income economy like ours, when I know as a matter of fact, poorer countries, I don't want to name them, in the southern part of Africa, freed the hand of their judges in the 90s. And I don't know why, and that will be, in fact, if I can achieve that, if I can automate all the courts within my 5 years, and I know I will be so passionate about that, I think access to justice will be almost resolved, because it's a key issue.
Yes.
Yeah, I know we have started because of COVID, we have started engaging in the e-filing and the CTSs and court management systems and all that, and the pilots we have. So already the pilots must be rolled out, and our budget should, from the exchequer and mobilized, should really focus on freeing the hand of the judge, making
automation, yeah, the
automation
third one?
of the payment systems,
Yeah.
and of course in transcription. This will completely revolution, hasten the period within which cases are resolved.
But very well. The third one, the third area that you may want to look at it differently.
We say motivation is a key element of so I want more transparency in the way various motivation is done to the staff within the judiciary. I already talked about why is it that one officer has got 2 state commendations within a period of a few years and all the other staff don't have. Why do we know for sure why this various motivation initiatives, what is the transparency of it?
Yes.
I think is what is important, so that we all work together as a team, because we are in it together, not for ourselves, but for the people of Kenya.
Yes, so any other area that you think you'll move in quickly and handle it differently? You've talked about staff matters, you want to see it to be done it differently, you say automation.
I believe...
what else?
Sorry, I believe once our key mandate is to shorten that case turnover rate.
Yes.
Once I focus on that, I will have touched so many other areas.
Backlog? Okay.
Yeah, backlog is in there. It will be tackled once we deal with the issue of hastening the processes by enhancing our ICT capacity and yeah.
Yes. Thank you. My second question is a bit outside what we've been discussing, and I think it was slightly touched by Commissioner Gishoi. Ease of doing business. I hope you have had ease of doing business, where the executive is playing their role in terms of infrastructure, in terms of, trying to shorten the processes, like even registration of business entities, trying to reduce the number of licenses, etc. And legislature also is trying to amend laws to align it so that business in this country is a lot easier to establish and to run. And there have been some bit of concern that judiciary, being a very critical player in ensuring, in any country, in ensuring that they create confidence to the investors, is not playing its role in Kenya as is expected. Cases take too long, disputes are done in a manner that investors don't understand, especially foreigners. Now, as you are coming in as a new Chief Justice, having in mind that Chief Justice Emeritus Mutunga laid the foundation and made things more easier, Chief Justice Maraga also came and fiercely defended the independence of judiciary. Kenyans are saying they want now a Chief Justice who has some kind of business philosophy, business-minded Chief Justice to help the country to attract investment and to help the country to create wealth. Do you fit in that description? And if so, first of all, you need to let us know if you are aware of the challenges that the business community is facing in this country in terms of investment and many other things surrounding investment. And what solutions are you going to offer?
Thank you. As I worked at the Federation of Kenya Employers, and actually most of the time as a deputy CEO of that organization in acting capacity, because I was head of legal, I interacted with the spectrum of all the investors in this country and employers. And the key concern was certainty of decisions made, especially in the labor courts,
yes,
the commercial division, especially because those are the, and specific on some key issues like procurement, which result in a lot of delays and nullification of tenders, specific key areas of concern to investors and any investor, and again, as a Chief Justice, being the embodiment of the judiciary, interacting with your college as your peers, and in our colloquia and in our education program, it is just a matter of really, you cannot have a policy of certainty of decisions made by judges other than educating them and on the need as we educate each other in our colloquia, and the Chief Justice taking a leading role, so that when we are seized of matters to do with major procurement, individual contracts, commercial contracts, that we prioritize those matters, and we utilize and precedents, especially because the Court of Appeal is key in this, because the different judges of the High Court will have different decisions. The harmony in commercial decision must come from the Court of Appeal. Actually, and I know they appreciate that more than any other court, because that is where commercial disputes should end, actually. So if there is certainty in the decisions of the Court of Appeal, there will be every investor will know, once I bring my money, this is what the Kenya law says. This is what the judges of the final court on matters commercial and matters labor are saying. So that is a key issue, and which I think I should be able to give direction as the embodiment. Really, you cannot have edicts to the judges. These are peers with independence, which I value and respect so much. Then the engagements. The judiciary has really opened up to the investors and business community, and that we have, I believe, a lot of initiatives in the commercial division and other already to ask them decision making, because that's the other thing. Delayed resolution of commercial disputes. Labor is a key consideration for an investor and for a Kenyan who is doing business, because that really impacts on their bottom line and ability to do business. So in fact, two issues is certainty of judgment and the turnaround period. Those will be my area of priority in that respect, understanding that growth of a country will depend on the levels of investment, local and foreign.
Yeah, on the same, they say that commercial division has lost its identity, its focus that was created to do. And Lands Court is another nightmare. Now everything stops at Lands Court. What are you going to do specifically with Lands Court, Commercial Division, and I think you have mentioned possible solutions to your court now. Those two, they say that nothing moves. If you go today to Lands Court, you will be given a mention or a hearing in 2023 or 2022, and an investor has come in with billions. He can't do anything, and many investors are moved out of the country because they are frustrated. There is no prioritization. Which to the investors, it looks like judiciary is not aligned to the government vision, to the government prioritization list of how do we bring investors that will come and create jobs for our people. So what action are you going to do? What is this that you can come and do as Chief Justice Nduma Nderi to enable this problem to be alleviated or even clearly moved from bringing problems to society?
It's a fact that land is a key factor of investment and business anywhere in the world, and more so in Africa and in Kenya. I'm aware that land disputes are multivarious and so complex, starting from the lowest level of the magistracy to the Land and Environment Court. I know that it is now a specialized court. Before, land disputes were open to the entire High Court, and therefore we narrowed these disputes to be handled by a specialized court, which I think now has 34 judges? If I'm not sure about that figure, but and ideally every county, every High Court station should have an ELC judge. And I think because land disputes are close to the people, and we in my view, that in the access to justice, a lot of consideration should be given to having enough, at least a land court in every county. I know the magistrates are doing their part, but there are those which must go to the High Court. I know the number of judges in that court is too small. It's too small, and should be a concern of any Chief Justice. It will be my concern because the jurisdiction is limited and no other judge can deal with the matters. So that, and of course, the rapid initiatives of disposal of cases, which we have been doing collectively, should be more focused in that area also.
Thank you. Thank you for your answer. My final question is on your involvement in community service. I've seen that you are currently the chairman of a secondary school in your home county. You also participate actively in your parish. You are once even a captain of Swaziland Golf Club, and you even pay school fees to many needy children. I wanted to understand your philosophy on public involvement and practice, giving your time to the community. What is your philosophy? What is it? I don't want to direct you to your philosophy. And as you're answering that, How do you anticipate your personal philosophy on the same? Would it be like, would it translate into some kind of character of your administration in judiciary when you become CJ?
Yeah, there's a lot of inequality in Kenya rising out of history, our history, and of course our stage in economic development. And so we interact with so many levels of inequity and poverty across. And I'm very, very grounded, first of all, from my formative years in my community, and that is why I have consistently been involved in focusing on education of the child, because I know within our communities where we come from, education of one child and frees not just that family, sometimes frees an entire clan, an entire community. That is my philosophy. And that passion of giving, I think, should be reflected in terms of community service within the judiciary. It should actually be mainstreamed within the judiciary, and I would work with all the stakeholders in the judiciary to mainstream programs which uplift the people we serve, our communities.
Yes, thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Before I call upon Commissioner Orwade, because after she talks, then the interview will be over. Judge, you talked very passionately about the independence of judges. And as a commission, we agree with you fully because, as you know, we have 4 judges in the commission. And we all feel, we all agree with that independence. But just a little bit of clarification, Your Honor. For example, we receive about 150 complaints against judges each year. So you can imagine for the last 10 years, we have received like 1,500. And for the last 10 years, we have only forwarded 8 of these cases to the president to form the tribunal. And out of those 8, only 3 have been removed. So the 99.5, we don't follow. And how we do it, Your Honor, when these cases come to us, we look at them, and a lot of them are merit-based, and a lot of them are decisional. So we actually don't follow, and even judges never get to know. However, there are some that we feel, let the judge come and explain. And then out of those people, out of those judges who come and explain, again, many of them, we agree with them. Out of that, there are few, Your Honor, that we feel, even though they have responded, let them come and explain further to the committee. So there's that, process that we follow. But eventually, a lot of the very, very few judges, of course, as you know, as I've given you, end up going to the tribunal. So because we also feel that the members of the public, Your Honor, and the lawyers who complain, we also have a duty to listen to them and then follow up. And my question, even as I explain this, Your Honor, don't you think the independence also can be abused? Is it possible for this independence to be abused? And my second part of the question, isn't it true that independence also comes with accountability? So that just because the judges, honorable judges, have got independence, we make sure that some of them, whether 1 or 2 or very few, are not hiding behind that independence to avoid accountability. So it's both a clarification and a question, Your Honor, before we go to the final set of questions. Thank you.
Yes. So I really appreciate that question, Madam Chair. And it is true that accountability is a constitutional edict for every state officer, a public officer. It's a command. Inasmuch also the independence of the judiciary, especially the decisional independence of a judge, is paramount. And that is born out of history of injustice and oppression, and where the judiciary systems have been used and mainstreamed actually to oppress the people. And that is, and when you read that history, you know that in as much as you want to deal with those matters which must be dealt with, especially to do with misconduct of a judicial officer, a very difficult balancing act must be there to protect especially the decisional independence of a judge. The moment that goes, we will all close our offices and go home. It will be chaos. And we often take that for granted. We are informed by history so that we never fall into the same pitfalls of the past. And it's true, I really appreciate the role of this commission in ensuring that judges and magistrates are accountable to the people of Kenya who gave this authority unto us. All I am saying is, as a Chief Justice, working with you commissioners, I want to make sure that those processes do not hurt the judicial independence of judges, because that is so central to the administration of justice. And the people well educated would never want to touch it, because they will be the victims and defeat them without the judiciary and judges protecting them, and magistrates and all judicial officers.
We agree with you, Judge, and I agree with you. It's a question of protecting that independence, but also making sure there's accountability. And I think that's a balance we need to also kind of respect. So thank you very much, Judge. Now I would request Commissioner Evelyn Orwade to ask her questions.
Thank you very much, Chair. Good afternoon, Judge.
Good afternoon.
My first question deals with the death penalty. Death penalty. The death penalty has been dealt with and discussed in our apex courts in several perspectives. 3 cases come to mind. We have the Ngotho Mutiso versus Republic case, Mwaura versus Republic case, then the famous Muruatetu, which you already spoke about. Now, Judge, I just need you to differentiate between the holdings in these 3 cases concerning the death penalty, and tell me your views, your personal views concerning those holdings.
I will try to admit that other than Muruatetu case, given my area of focus, right now in the judiciary, I have not interacted directly with those 2 other decisions, but if you were to give me the ratio in those decisions, then I'll be able to give you a very good answer on what I think.
In the Ngotho Mutiso case, The ratio concerns the constitutionality of the mandatory nature of the death sentence, and the finding was that the Constitution does not restrict discretion on the subject of the death sentence, specifically in respect to murder trials. In the Mwaura case, the question was whether the death sentence was unconstitutional by virtue of it being or offending against the freedom from torture, inhuman and cruel punishment. And the Muruatetu, of course, you said you know.
Yeah. First of all, I really appreciate the Supreme Court decision and direction in allowing judicial officers to have discretion based on the facts of each case on issue of death sentence. Of course, the Supreme Court left that death sentence as a lawful remedy because I believe that is still our constitutional edict that death penalty was not still a lawful sentence in our constitution. I think central to all that, and to which is applicable in my own view to any registration which hinders the discretion of a judicial officer by giving a minimum sentences, is that we should have none, because the function of a judicial officer is to balance each case on its own facts and merit, so that we do not see, for example, a lot of injustice, which I think we've read about so much, about the young boys languishing in the cells all over for longer times than they would have, and the judges been given discretion to consider their specific circumstances in each case. So that is my view, without going to the details of those cases, because I haven't interacted much with them.
And what about the death penalty itself? That is about the discretion. What about the death penalty?
Sorry, I've just said that our constitution did not outlaw that, and I believe that is why the Supreme Court did not go that way. And but the law evolves all the time, depending on the context of each nation. And I'm sure this is not the last we've seen of that in our development of law and justice in our country.
Okay, thank you, Judge. Under what circumstances can a public officer maintain an account outside Kenya?
You have to be specifically be allowed to do so by a parliament registration. If there is no enactment which allows you to do that, then I think you're prohibited by the Constitution itself to do that as a state officer.
Do we have an enactment that allows as we speak?
I'm not aware of one.
You're not aware of it?
I'm not aware of it.
We actually do. The Leadership and Integrity Act. It gives the circumstances under which
yes, I have seen
you can maintain an account.
I have seen that.
Okay,
yes.
Thank you, Judge.
Yeah.
Can a Chief Justice hold dual citizenship?
A state officer should not.
A Chief Justice?
As a person holding a state office, I believe, should not have dual citizenship. A state office.
I'm specific to a Chief Justice.
No.
Not at all?
Okay, judges, I know, can have dual citizenship. I think also maybe the Chief Justice, I must admit, I'm not sure, but I think judges may have dual citizenship in terms of the law.
The Chief Justice is a judge, my lord.
I would want to reflect on that, on the responsibility of the Chief Justice, but I think as a judge, then he should have, because judges may do that. Yeah.
Okay, thank you, Judge. I must admit I was getting quite excited when you were giving your exposition on the issues that plague especially members in this institution, in the lower cadres. As you said, you lifted from the employee or staff satisfaction survey. You hinted at what you propose to do concerning some of those issues, one being discipline, which you said you are looking to developing a framework that will help the process to be fair and just, which basically to me, in my ear, sounded like a complaints handling mechanism or policy. And then you also talked about promotion. Promotion is also an issue, especially for judicial officers. Because you know, we all, I think about 95% of judicial officers aspire to ascend to the superior courts. The superior courts are like canon for them. But before they get to that canon, there are several red seas they have to cross in the form of promotions. Now the challenge here is there is no indication when this red sea will open. And that is the problem, like you aptly put it, with our promotions. So I want to hear from you, Judge, and for your prospective subjects, if you become Chief Justice, for their benefit, what would you do, or what do you propose to do to arrest or address this problem?
Of promotion?
Yes, my lord. It actually affects not only the magistracies and the cadres, even the judicial staff. It's a very sore issue.
I am very, very aware of it. Not now, just for purposes of this interview, but I've interacted with that as a principal judge immediately as I was serving. I interact with this because as I said, I'm a very interactive person, so I speak to judicial officers at every level freely and openly, and so I am aware. For example, what happened to those who had applied last time round to be promoted from magistracy to...
Actually, Judge, I'm talking about promotion within the ranks of the magistracy, the cadres, and judicial staff.
Yes, I'll come back to that, but I wanted also to tell you that I'm aware that even as a chief magistrate and tried to become judges, I was aware, and because I interacted with them, that it appeared as if there was a minimum age, number of years you must have served to be even shortlisted, although it is not part of an open framework. And I believe so much in transparency and based on documented and developed through interactive processes, so that if we are having problems of career progression from the first level of magistrates to the next one and to the next one, and same with the other cadre in the not in the judicial service. What we need, I know we have a big human resource manual. I'm also, if you look at my CV, I also trained in the South African Institute of Management on matters human resource. So I'm very aware of difficulties of implementing policy which is hidden in big books and not translated into small, workable documents accessible to everybody, so that they know this is a criteria from moving from a resident magistrate to the principal magistrate. And these are the considerations, and they must be taken into account. And this is becomes a policy document that must be developed as a working document for implementation purposes. That is the only way you will ensure that there is fairness in the movement of judicial officers at every level. It's transparency in and developing accountable small frameworks extracted from the big book, so that any JSE dealing with promotions is alive to the fact that everybody knows what the criteria is, and that they have been commanded by, or they have commanded themselves because of course the document eventually will belong to JSE to follow this line, and sometimes also that also, once you have transparency, you deal also with perception. There's a reality and there's perception. But in this case, I know there's a lot of reality. But transparency also kills perception and acceptance of whatever decision JSE makes in promotions. So that's the key.
Thank you very much, Judge, for that response. My next question I've lifted from what you said earlier. You said a court order has to be obeyed, whether the person agrees with it or not, because to do otherwise would lead to anarchy. Now I want to ask you, if a party is vehemently opposed to an order that has been served on him because he totally doesn't agree with that order, what is his remedy?
He must implement it and seek redress.
In what way, my lord?
He will make an application to have the order set aside. If he does so immediately, then the matter will be reconsidered, because there's always room for review of orders of court. But if you do not move an application for review, or you don't file an appeal, then you must obey the court order. And even if you move for review, or you file an appeal, and you apply for a stay pending the hearing, and you don't get it from the court, you must obey that order.
Thank you very much, Judge. Now, another concern I want to raise with you concerns the membership in your court and the other specialized court. There is a general feeling that they are not put at par with the members of the High Court. I'm talking about the courts of equal status. And when it comes to nomination, which is almost more or less the same thing as promotion for magistrates, to the Court of Appeal, they feel like they're disadvantaged. What would you do to address those concerns if you become Chief Justice?
Thank you very much for reminding me of that. I should have even talked about it earlier. And those of us who sat with me at the JLAC know that I was very passionate about that, and I actually brought concept papers. I was asked to, because of my persistence, that let there be equality, because the Constitution tells us we have established courts of equal status, and therefore let us treat them equally in all matters across the board. And I remember during after the last elections in 2017, and JLAC was faced with the issue of swearing of governors, and the view there was that an ELC and an ELRC judge is not qualified to swear a governor. And when I persisted and I asked to be shown which part of the Constitution says that, which law outlaws us from doing that, of course I lost by vote, having been told to present a paper on it, and to because of my persistence in there, that we are not being treated equally. Having sworn governors in 2013, myself, I swore the governor of Marsabit and Justice Mutunga. I went to swear that time the entire assembly, the speaker and everybody else, plus the governor. And then all of a sudden we were not qualified to swear judges. Then I also presented concept paper there about judges of ELC, with the support of Okongo, the PJ for ELC, being appointed as presiding judges. I think it's a matter I followed up persistently, and I was not successful, because up to now, indeed, no ELC judge or ELC judge is a presiding judge. And we witnessed also judges who had earlier on from ELC elevated to presiding judge being demoted, and judges who had just been appointed being elevated to be their bosses at those respective stations. We saw that happen, and you can only talk because you're in an advisory. While I was the principal judge, we are there to advise the Chief Justice, and I did so passionately that that has not borne fruit. But in one way, it did bear fruit. SRC then gazetted allowances for presiding judges, which include ELC and ELRC judges. Again, after that happened from SRC, I took up the matter again with the current principal judge of my court, and especially in our specific colloquial, annual conference with the Chief Justice, and we have been not successful to date. It's an area of dissatisfaction and a feeling of unequal treatment, I must say. Thank you for reminding me. And it's an area I would want to tackle with JSC, as soon as I'm Chief Justice, if that be the case.
Thank you, Judge. Now, you are aware that after receiving applications from all the candidates, JSC had to take them through a vetting process. We sought information from members of the public out there, and we got information. We got complaints from various quarters. In keeping with what the chair has just told you, we got quite a bit in respect to you. Some of them touching on your decisional independence. We shared them with you, you responded. We have your response, we are going to consider them. But there's one particular one I want to raise with you, Judge, without necessarily mentioning the parties, but I'm sure it's a matter that was brought to your attention because I have seen your response. In this particular matter, the complainant was engaged in a legal tussle with his employer. And the long and short of his complaint was that at some point on disciplinary hearing, I suppose, on accusations which in his view were based on vendetta from his employer. The matter was heard, the board absolved him. Subsequent to that, the employer was not happy, and the employer changed the membership of that board, called him for a second hearing, which of course he refused to subject himself to, because in his view, he had already been absolved the first time. So of course they were engaged in a legal tussle before your court. And at some point, not necessarily handled by you from the beginning, but at some point, the complainant came before you seeking orders to suspend the order terminating his services and his pay. And you granted him those orders, ex parte. Subsequent to that, it appears at some point the employer stopped paying him, and he came back before you about 4 months or 5 months later and applied for the employer to be held in contempt. Now, instead of doing what he expected you to do, to hold his employers in contempt for disobeying your order for that period, what you did is you dismissed his application because he failed to disclose certain material facts when he came before you ex parte. Now, you are within your discretion to make that decision, but I'll tell you why this concerned me a bit. We already agree that if a party is aggrieved with a court order, it's upon him to approach the courts for necessary action and to do that promptly. It is not upon a party to decide that I agree with this order or this order is unfounded and I will not obey it. From the narration of events, I also read the judgment that you made. It seems to me that the employer in this particular case, between the period you made the order ex parte to the point the complainant applied for him to be held in contempt, he was in contempt. But in your decision, you focused only on the failure of the complainant to disclose material facts, but you said absolutely nothing about the conduct of the employer in disobeying your order, which was actually the subject of the application, in disobeying your order for the entire period until the complainant came before you. This is a concern because we are all aware it's in the public domain that disobedience of court orders is a very sore issue in the administration of justice. And the concern is, as Chief Justice, should we have concerns that you may not be up to the task when it comes to enforcement of court orders?
I think I remember that one, and I appreciate, and I responded to it in writing. The issue there is what was the nature of non-disclosure to me. I remember as I was handling that matter, is during COVID period. I'm operating from home in Nairobi, there in Kisumu. And so, when I gave the ex parte judgment, ex parte orders, it's on a basis of an online application. I don't have the file in my house. And there goes a need for an applicant in those circumstances to give me all the circumstances of the case before I issue the order. And what was the nature of that information? That the same matter was before Justice Morino Nyango, who had considered it and issued a ruling on it. So when the matter came for an inter-parties hearing, that was disclosed to me, and actually an opportunity to see the ruling of my sister judge, which if it had been disclosed to me, I would never have issued that injunction. That is why I dismissed that application on the basis of non-disclosure. That was such a material non-disclosure that my decision was in direct conflict with a ruling already done by my sister judge. And therefore, I exercised my decision-making reasonably after considering the circumstances. and the kind of non-disclosure which was not made to me.
My Lord, this non-disclosure you discovered in the application for contempt by the complainant.
Yes.
You were not moved by the employer. Is that correct?
No. If you look at my ruling, I consider the submissions by the employer, they're the ones who disclosed this to me.
In the application for contempt?
Yes.
Thank you, my Lord.
Yes.
Okay, moving on to the application documents that you filed. I don't know if you have your files with you, your papers with you, the applications that you filed.
The application.
If you look at the advertisement that was put in the papers, the applicants were required to download Form 2, JSC 2A for public officers or JSC 2 for other applicants. This is in keeping with the statutory provisions in the first schedule, Regulation 4, that requires you to fill a prescribed form in making your application. Did you fill that form, my Lord?
Yes, I did. This is a form I filled. I downloaded and filled in the...
My Lord, I saw what you downloaded. It is not Form JSC 2A. That is the online application. It is not the prescribed form. If you look at the advertisement, I'm sure you have a copy of it in your bundle of documents.
Yes,
the advertisement required you to fill that online application and amongst other documents, download Form 2A, JSC 2A, fill it and upload it along with your application, the online application, as well as submit one hard copy of Form JSC 2A, which form is supposed to be filled in your own handwriting. You did not comply with that, my Lord.
The form I had allowed me to type in that part. And so this is a form I brought, and where there was space, there is space for typing, I did my typing, and I believed and I said that I filled the correct form. If indeed this particular form is not the correct one, I do not know until this point, but I believe this one, the form I downloaded and filled, presented me with opportunities to deal with the application appropriately, including filling the part which was supposed to be done about my own information, which I duly typed.
Okay, my Lord, if you look at the form you submitted, the way it is, because that is how it has been presented to the Commission, in Form JSC 2A, or even Form 2, at the end of it, there's a declaration where the applicant is attesting to the truthfulness of all the information he has given in his own hand in Form 2, JSC 2A.
Yes.
Do you have that in your form?
Yes, I have, and I duly signed.
Is there a declaration on that form?
Yes, at the last page, and there's a signature in PDF.
The one I have, my Lord, sorry, the one I have does not have that declaration. Maybe we'll get to look at the copy that you have.
It is there. Maybe there's a...
Could you read the declaration, my Lord? The declaration you have in that form.
Oh, the last part says final declaration, and then the declaration date, which I put, and the signature in PDF. That's the last.
Just read the declaration, my Lord.
It would appear that
there's none.
This is just in the printing, but it was there.
That's my point exactly, my Lord.
It's just in the printing, but the declaration is there, duly signed and filled by myself, and dated the 8th of February 2021.
Okay, moving on to the next issue. Did you apply for clearance from the EACC?
Yes, I
Ethics
did.
and Anti-Corruption Commission?
Yes, I did, and I have presented the originals today.
Okay, thank you. Is your wife a public servant?
She is not working thanks to COVID. She's never been a public servant.
In your wealth declaration, you are required to give a schedule of your income, your assets, and your liabilities. Why do you think we ask you to give all those details? Why not just ask you, tell us what you own? Why do we ask you to give your income, your assets, and your liabilities?
I did that. It's a part for the income, those three.
My Lord, I'm not asking what you did. I'm just asking you why, the rationale, why we are asking for those three components, not just for you to declare your wealth and tell us, I own blah, 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 blah.
It's an issue of integrity.
Yes. Why?
Yes. It's in terms of the Constitution and the code of conduct that we feel, and we've been feeling those forms. It's not the first time we are doing that, and that is why we have filled for the past many years.
Yes, my Lord. What do you think we do with that information? Your income, your assets, your liabilities. Clearly stated in different paragraphs. What do we do with that information?
I'm not sure what you do with it, but it's supposed to reflect my correct status of income and assets.
Okay, let me ask you this, my Lord. If in your schedule of assets, because we fill these forms...
There's no new property.
I'm not asking about your case.
Yes.
What if it's a new property? Should that be a cause for concern?
If it is a new property, yes, there will be a cause of concern which does not apply to me. I do not have any new property because most of my assets there were acquired mainly from my work outside the judiciary, and the assets acquired when I am a member of the judiciary, acquired through the mortgage, judiciary mortgage, okay, and
if I may ask, my Lord, which property was acquired through the judiciary mortgage?
That is my home in Lavington. That was acquired through judiciary mortgage, which I have also reflected that the amount of loan outstanding.
So you stand by your word that there is no new property in your declaration?
For the period covered, the period of 3 years?
The last three declarations.
I have disposed of, if you look at them, there were properties which were there, and they are no longer there because they have been disposed of. And there is only one piece of land which was acquired, but I have also disposed other properties. If you look at carefully, I have, you will see that properties which were there at this time, they are no longer there, and there's, I think, only one new property, just one, but the values, the change in values are just a matter of market rate, not because the properties have been there.
So you say you've acquired some property out of disposing others?
Yes, you look, yes. And
is that reflected in your declaration?
I believe you have, when you look at my statements, bank statements, which are from 2017, you will be able to see disposal of property. Okay?
Is that reflected in your wealth declaration?
It is in the statements. In the declaration, you will see.
My Lord, what I would expect is this. Maybe I can just break it down for you so that you understand my concern.
Yes.
What I would expect is this. If I have three properties, property A, B, and C, I dispose of B and C and subsequently acquire X. In my last declaration, I had A, B, and C. What I would expect is, in my subsequent declaration, B and C would not appear, but there would be income showing on the space where I'm supposed to indicate income, that I got income from disposing property B and C, and subsequently acquired property X. And that's why I'm asking, is that reflected in your wealth declaration?
If you read that in conjunction with my bank statements, it's very well taken care of.
Okay, let's move on. Let's move on, my lord. There's a company, I'm assuming it's a limited liability concern, called Cited. In your wealth declaration, you have mentioned it severally, but my concern is you have not disclosed what your relationship with Cited is, and if you are one of the owners, in what ratio your shares are, and what it is worth.
That company is not operation. It's there, but it's not. Since COVID, is not operational. Since 2006, it's a business by my wife, HR consultancy, which she has done since 2006, and submitted accounts to KRA, financial statements for all that period, and I have indicated that in my declaration. We don't have much space to say other than indicating our personal emoluments, and I indicated that the accounts of that company have been filed since 2006 with KRA.
What is your relationship with Cited? Do you have shares in Cited?
Just a family. What is it called? Is it called nominal one? For that time, because you could not register with as a single director.
So it's a company owned by your wife?
By my wife, and she has consistently filed accounts, and that is why we got clearance, I believe, from KRA, because she has been compliant throughout. But now, there was a small family concern.
Okay, thank you.
She's been running it herself, and now it is not operational because its area of focus could not go on due to the international, the closure of international boundaries, because our focus was outside the country. She was training and personnel mainly from without Kenya, and that's why she could no longer operate.
Okay, thank you. And are you a Sharia SACCO member?
Yes, I am, and I provided statements to that. I don't know whether you've received my bundle of statements.
I saw your bank statements.
There is also a bundle of statements from Sharia SACCO. Which one?
You also did not declare indicate the dividends amongst the income that you get, the SACCO dividends.
Yes, they are all in those statements, because all along, I must say that we have been submitting these wealth declarations, not for purposes of interviews. And those forms have no space telling you indication that you're supposed to make attachments. We have never been asked to attach any document to those declarations. In fact, I'm sure almost all the candidates were surprised by the requirement that we attach bank statement, because it was not apparent at all in the advertisement. We've never done it before. All what we do the estimates of our income, and we declare our assets, and we don't attach any documents.
Actually, my lord, maybe to make it clear,
but
because
you
now
will see the attachments of my bank accounts clearly show my little contribution on a monthly basis to Sharia SACCO. They show that whatever dividends they pay match. They also show the loans the loan I have taken there, and they show my contributions to date. And so, for purposes of accountability and transparency, you will see everything in that statement from Sharia SACCO.
Okay, thank you, my lord, for submitting your statement. I saw your statements this morning, but I just want to make one thing clear. We did not ask for bank statements. I know this must have come from the questions that the previous candidates have been asked. What I've been asking about is declaration of your bank balances. If you have an account, you have money, that under Section 2 of the Leadership and Integrity Act, in that description, money is one of the assets that you have. So that if you have 2 million in your account, all you're required to say is that I have an account at this bank and the balance there is 2 million, because that is part of your asset, not necessarily the bank statements. And at the same time, about the forms, you are always at liberty to attach an extra form or an extra paper detailing your assets if the space there is not sufficient, just to set the record straight, my lord. Otherwise, thank you very, very much for your patience. I'm done. All the best.
Thank you. Thank you.
Commissioners and Your Honor, this brings us to the end of this interview. And
local clarification.
yes, Honorable DCJ.
Thank you. My lord, there is something you said that I think we should not leave hanging. And you said that the manner in which the Supreme Court has handled, you are calling them two, but the Supreme Court has actually handled 3 presidential election petitions, has left uncertainty. That's what my lord said.
Has left?
Uncertainty.
Oh, uncertainty. The two. We were focusing on two of them.
Then my lord has also expressed dissatisfaction, I think that's what I got, about the Weber case. So those are 2 concerns there. This is the question. What in law can or should be done about those judgments? Now, when I asked you the question in the beginning, I said, you give us either a critique or a criticism. I do not know what it is my lord gave us. Was it a critique or was it criticism? But whichever it was, because both are okay.
Yes.
My lord feels that we have convoluted issues rather than shown the way to go. In both the election cases and in the Weber case. And so I ask, this also is a learning process, or is it not? So I ask, my lord, then what are we to do? What do we do with those judgments?
Maybe convoluted.
Within the law, not what we feel. Within the law,
yes.
What do we do? That's the first part. The second part, when my brother, the Law Society representative, was talking to you, there's something there you said about the big picture, right? And I want to know whether that big picture is part of our jurisprudence and how it relates to constitutional interpretation theories. Those 2 clarifications, my lord.
On the first one, maybe convoluted is a strong word. I did not use that. But especially on the Law Society case, its impact on the ground is very, very real. There's a lot of disaffection in the way, especially from the court users.
My lord, that I had, that
yes.
we had, and
preparing to
and
answer
incidentally,
yes,
we began there.
Oh, I see.
During my practice, we went to the director first before we went to any court those days. So, of course, you answer the question in the manner you best think is the way to satisfy us. But for me and my constituency, it is that critique or criticism. The judgments stand. They are the judgments of the apex court, the final court in the land here. And so I'm asking, in the law, because we can only act within the law, what are we to do?
Okay. Actually, there has been a lot of robust discussion of that amongst ourselves and LRC court, because we also realized we are handling the issues differently, and we also got a long memorandum from the magistrates raising the concern that in the court users committee, they have a representative saying that they are totally confused. They don't know what to do, and there's a lot of disparity in how the different officers are dealing with it. And so we said, the opinion was, let the matter go slowly up to the Supreme Court to be dealt with. And in my view, I strongly I think that may not even happen, because that depends on the court users to move. But this case, we have a particular court user, the Law Society, which, with its capacity of legal minds, probably would want to engage the Supreme Court once again on that particular remedy for clarification, so that then you can also now reconsider the matter quickly and give an edict to the rest of the courts. That would be a much quicker way, but of course it depends on the court user. From where we sit at the judiciary, we can only watch as decisions are made and they come, hoping that one day they will reach you again, and which I think is not a satisfactory way of dealing with our court users. So that's one. The other one was,
my Lord, it was the use of the word, the bigger picture. And so I'm asking whether that is an emerging form of jurisprudence, and whether how have we been interpreting the Constitution? Are there not enough theories on how to interpret the Constitution, and is the bigger picture part of that jurisprudence?
I do not recall myself using that particular word in that context of interpreting the Constitution, because I said very clearly that the Constitution has got commands in various articles telling us how we should interpret it and what values and principles we should use. I think that was my bottom line, but I don't think if I used the word bigger picture was in that context of interpreting the Constitution.
Thank you, my Lord. As I said, it doesn't matter whether it's a critique or criticism.
Well, it was a critique. I think we are bound by the decisions of the Supreme Court.
Actually, that's the word I was looking for.
And you have seen that in some of my judgments I have submitted. I have a lot of deference to your decisions of that court, but I think
it is criticism.
A critique is good at this kind of forum.
It is criticism that would make that court grow, or any court for that matter.
Yes.
But it has to be criticism that is within some parameters, isn't it?
Yeah, within the law.
Yes. I thank you, my brother. I thank you.
Chair, just to Chair.
Yes, we need to bring this to an end, Commissioner, but go ahead.
Yeah. I mean, just arising from what the Honorable DCJ was asking, like you mentioned about that case of Weaver, where a good decision, but so many other complications arising.
Yes.
You know, the big picture in that sense, that when the decision is being made,
I think so.
You as the CJ ensuring that you look beyond the decision and the implications. Same thing also with Muruateto, where good decision, but again all the courts interpreting differently and coming up with different parameters, so causing more complications.
Yes.
So I don't know that so big picture in that sense, are you able to expound what kind of a CJ would you be to ensure that even as you're making the decision, you're able to foresee that in the implementation, it doesn't end up causing more problems, even as you're coming up with a constitutional interpretation and principles?
Well, as I said, that as the Supreme Court, even as the Chief Justice, we are only but a college of judges, with me being the first among equals, and the DCJ being the second, and we cannot just use the best of our persuasion to make sure to sensitize ourselves on the need to issue effective court orders, especially if matters are likely to affect a very big constituency like is happening now. The Supreme Court itself has addressed itself very much on the effectiveness of court orders, and in particular in Mitubel case, where they felt very strongly that the orders of the High Court were not effective and they were general and they'd set them aside. So I'm actually speaking from the mouths of the Supreme Court judges on the need to have effective final orders which are capable of implementation. So I think that is, if the big picture was in that context, then I think that was the view of the Supreme Court, especially very strongly expressed in the Mitubel case. That is what I was talking about. We need to have effective orders capable of implementation without causing hardship. Yeah.
Thank you very much, Honorable Judge. We will stop there. We want to thank you, Judge, for your, number one, applying for this job and also availing yourself, and also talking very passionately, Judge, about what you believe in, and also being very candid and very honest. We want to thank you for that. And on behalf of the commissioners, we wish you well. But before you go, do you have anything you'd want to tell the commission, Judge?
Ni vema na haki ni mshukuru sana sana kwa vile mmenitendea haki na mmeendesha hii hafla kwa njia inayofaa, kwa makini, hekima na utulivu mwingi. Kwa kufanya hivyo, nafaa nimpe sifa, manake kazi yenu inapatia Kenya yetu sifa. Na mnapata sifa katika ulimwengu wote na mbele ya Mwenyezi Mungu, sifa nayo inastahili mpate. Na kwa hivyo mimi nawashukuru sana, nampongeza na wahisi muendelee vile vile mpaka mtakapopata jaji mkuu atakayetumikia Kenya kulingana na katiba yetu ya Kenya. Mungu awabariki na waongoze. Asanteni sana.
Thank you very much, Your Honor. So we come to the end of this session. Your Honor will be escorted out by Honorable Anne Amadi. Thank you.